Please only ask for the time that you need to get out the salient points of your argument. We have read the briefs. We are fully familiar with your arguments. The light is for you. It's not for us. If, in fact, we have additional questions that we are going to ask, we will certainly ask them. People v. Alexander Arola. 5-1 and 5. I am recused on that matter. Tong v. Granite. You have a cross appeal?
No, I don't. I'm not chairman.
Oh, okay. And so let's start with the appellant. Appellant?
Yes,
Yes, Mr. Tong. How much time are you requesting? I'm sorry? Okay, so that's 5 and 2 and 5. Matter of H. Hanley, children of H. Hanley. That matter is submitted. Just for the record, Justice O'Neill Levy is recused on that matter. More Reason versus Manhattan College.
Respondent requests 5 minutes.
525. Began versus Akibono Brake Corporation.
Appellate request 7 and 2.
Hi, are you the respondent? Okay, 5, 2, and 5. And by the way, Justice Friedman is recused on that matter. Magnan versus Watsky and Dam. 525. People v. Gardner. That matter is submitted. Pena v. American Industries.
Request 5 and 2. Respondent requests 4.
524. Katacumbas versus Katacumbas. 4 and 1. 6241. People v. Kendall Watts. Those are 2 appeals. Both are submitted. Martinez versus Stericycle Incorporated. That matter is submitted. Alvarin versus NJ Transit. That matter is submitted. People v. Jason Percy. That matter is submitted. Mahia versus 770 Broadway owner. Oh, we were on a roll there. Okay. Who do you represent?
Defendant repellent.
The defendant repellent? No, you don't repel us. No.
Defendant respondent repellent 5 and 2, Your Honor.
Who's next?
Third-party defendant respondent Rock 6 minutes.
Rock, you're requesting?
6 minutes.
Defendant respondent
Second third-party defendant.
RB New York Enterprises 5 minutes.
Okay, 5 and 2, 5 and 2, 5 for third, Rock, and RB 5.
Defendant respondent requests 5 minutes.
Who are you?
Watsky?
Lotzik, 5. Thank you. Oh, People v. Jaswan McCrae. That matter is submitted. Rodriguez versus Riverside Center.
Plaintiff requests 5 and 2, please, Your Honor. Respondents Fishman and Riverside request 5.
So Fishman, okay.
Respondent Bannister request 5.
Okay. 5255. Vigliano versus Gaines.
Appellant request 7 and 2. Good afternoon, Your Honor. Stephen Sachs, we work for our regular appeal on the injuries of Parker Zachary Klein Sasser from Boston.
Is it colder in Boston than it is here?
It is.
So, yes, so that's why you wanted to come to New York? Okay. Appellant, you're requesting 6 and 2? 7 and 2, sorry. And you're requesting? Okay. 625.
Your Honor, respondent.
Oh, I'm sorry.
Respondent in that case, United Talent Agency request 2 minutes.
Okay. 2 minutes for you. 6 and 2, 5 and 2. Magnan Dairy versus Apis Capital Advisors. That matter is submitted. First matter for argument is People v. Alexander Areola. As I stated, I am recused.
Go ahead.
Good afternoon, Your Honors. Kathy Liu, Center for Appellate Litigation, representing Mr. Alex Areola. Mr. Areola's lengthy 18-year sentence is harsh and severe because he was suffering from a serious mental illness at the time of the offense, which represents his first and only criminal conviction. Moreover, he has already served over 13 years of incarceration, which is more than twice the minimum of 5 years.
So, counsel, did he waive his right to appeal?
Your Honor, it's our position that the appeal waiver is invalid in this case
invalid
because
about
we cannot be confident that on this record, Mr. Areola understood that the waiver was not a complete bar to appellate
Did he
review.
indicate in any way, shape, or form that he didn't understand that?
Well, it's
In fact, he answered yes to every single question, asking him if he understood it, correct?
well, when it came to the written waiver, which is
Just
the
asking you whether he answered yes that he understood.
he did, but
And,
still,
should we assume that he was telling the truth when he said, yes, I understand?
Perhaps in other cases, we can assume that the defendant understood when they respond yes, but in this case, no. The court should have done more to make a clear record that his understanding of the consequences of the waiver are evident from the record. And we just can't have confidence here because not only was the colloquy deficient, because the
How was
court...
it deficient?
The colloquy was deficient because the court never explicitly informed him that the appeal waiver did not categorically bar him from raising all claims on appeal.
Was
or
there a
enumerate-
written waiver here?
Yes, there was.
And was he represented by counsel at the time?
He was, but we still cannot have confidence on this record that he was able to understand the written waiver because it contained a whole host of new and inconsistent information. The court's colloquy indicated that the sentence and conviction are final. However, in the written waiver, it contained a whole host of additional claims that he can raise on appeal. And we can't have confidence in light of Mr. Areola's vulnerabilities that he was able to internalize and understand the new and inconsistent information in the form. Now, if I may, I would like to turn to the mitigation here.
Is there anything in his background which indicates that does not have the capacity to understand something like this? Didn't he get an equivalency degree after dropping out of high school, and then didn't he get training for electrical work, if I recall correctly? I mean, you make this point how he's done all these things to show that he's got capabilities, and now you're standing in front of us and saying, well, he couldn't understand the writing and the written waiver.
So, Your Honor, yes, he is particularly vulnerable because he had lived 30 years in the community without having any criminal record. So the whole concept of an appeal waiver was entirely new to him. He had never previously accepted a felony plea or been
It might be
subjected
new
to
to
an
him,
appeal
but I mean,
waiver.
there's the plain writing of the waiver. I mean, what reason is there to think that he didn't have the capability to understand that?
Again, he's inexperienced with the criminal legal system, and I would also like to remind the court.
Wait, are you arguing that only someone whose fifth conviction would be someone who could understand an appeal waiver?
So the standard here is the totality of the
Right.
circumstances.
So
and we
what
must-
you just said was because this was his first time with the criminal justice system, he couldn't understand the waiver. Is that what you intend to say?
It was especially difficult for someone in his situation to understand the
Of course,
consequences
right?
of the
But he has a
waiver.
lawyer, correct?
Correct.
A lawyer explained the waiver to him, correct?
No, that's not correct. The record indicates that the written waiver was presented to him after he had already made an on the record waiver, and so it was presented to him after that. And even though he was able to review it momentarily in the court,
Well,
we
he
can't have
reviewed it
confidence-
at the time, and he didn't make any indication that he didn't understand it, correct?
Well, the court actually never confirmed that he did understand it. The court never said, "Do you understand the written waiver?" And we don't have
Anyhow,
confidence that he
turning to
did
the
here.
merits of this, in reading your brief, you speak about the fact that when the defendant killed the victim, he stabbed him, but you make no mention of the fact that he also shot him.
We're not disputing the severity of the offense, Your Honor. In this excessive sentence claim.
Okay, you have time in response.
Okay,
Thank you.
thank you.
Good afternoon, Your Honors, and may it please the court. Kalani Brown on behalf of the Bronx County District Attorney's Office. Your Honors, we respectfully
There is
request.
no question in this case that not only did the defendant stab his cousin multiple times, he also shot him.
Yes, Your Honor. The autopsy revealed that the defendant did have a gunshot wound to his right arm, which pierced his right lung, as well as multiple stab wounds to his neck. There was blunt force trauma to his head, abrasions to his shin, and so there was a lot of violence.
Wasn't his wrist or arm broken also?
I'm sorry, could you
Wasn't
repeat?
his wrist or his arm, his elbow broken also? There wasn't.
Yes, Your Honor. His elbow was also fractured.
Counsel, this was a negotiated plea, correct?
Yes, Your Honor, this was a negotiated plea. The defendant could have pled not guilty by reason of insanity, given his dangerous mental illness, but his counsel and the defendant knew that he would be institutionalized at a psychiatric hospital almost for the rest of his life. And so given that he was able to plead guilty to a definite sentence of 18 years for first-degree manslaughter, as opposed to the life imprisonment
Having
he
been
could have
charged with
received.
murder in the second degree.
Yes.
He pled down for murder in the second degree,
Yes, Your Honor.
facing a 25 to life sentence.
Yes, Your Honor. And there was sufficient amount of evidence to convict him of second-degree murder to give him up to life imprisonment. And so the defendant knew he was getting a definite sentence here, which is why he was able to plead guilty. He did have a
Counsel, as to the colloquy regarding the waiver of the right to appeal, would you agree that in addition to the judge's allocution, that the written waiver together, in totality of the circumstances, makes it a valid waiver?
Yes, Your Honor. And given that the defendant did validly waive his right to appeal and the court explicitly and thoroughly went into the trial rights, the appeal rights, that it's separate and distinct from each other, they went into the fact that he can file a notice of appeal within 30 days. And correcting the defense counsel's claim, the court did say that the appeal waiver is normally final, not all the time, normally final, and the defendant is giving up most claims of error, not all. And so the written waiver does remedy any ambiguity that could possibly be present in the oral colloquy, but the court was very clear and concise with its description about the appeal waiver, and so there was no, the defendant, excuse me, had ample opportunity to say that on the record that he didn't understand, and the court explicitly said, by signing the waiver, let us know if this is something that you're confident in signing. And so they were able to confirm before signing the waiver and after signing the waiver that the defendant knew the rights that he was giving up.
Didn't the court also ask him if he has spoken to his attorney about his waiving his right to appeal?
Yes, Your Honor, and the court additionally spoke to the attorney and said, I would like you to thoroughly explain the waiver of the right to appeal to the defendant and make sure it's up to his standard. And so, Your Honors, if you have no further questions, I will rest on my brief.
Thank you.
Thank you.
Yes, so Your Honor, I would like to address your question. So you had mentioned the severity of the offense, and that is something that we're not disputing. But when this court considers Mr. Areola's excessive sentence claim, it can't just look at the severity of the offense. It must also look at the mitigating circumstances of the case. This is under People versus Farrar. And here, there are compelling mitigation. It's not disputed that Mr. Areola was struggling with psychotic symptoms at the time of the offense. And given these symptoms, he's necessarily less morally culpable. And this court has repeatedly recognized this in the cases cited on pages 14 and 15 of our brief. And most recently in People versus Sparks. The court recognized that when the crime arises out of mental illness,
That was
client
very
is-
different facts, counsel. I was on that panel. Those was very extremely different facts from this case.
would also like to point the court to the People versus Fisher case, which are very analogous facts, and it's on pages 15 of our opening brief. And that was also a case involving manslaughter and also a death of a relative. And this court, in that case, reduced the sentence from 18 to 14. So we respectfully ask the court to grant a modest reduction of 1 year, which would make his conditional release date March of this year. Thank you.
Thank you. Thank you both. Tong versus Granite.
Yes, whenever you're ready.
Okay, good afternoon, I guess. Our contract basically is a contract civil case.
If you could just move the mic a little bit closer.
sorry.
to you. That's okay. Thank you.
We enter into a annual lease agreement. Original, the tenant in our case is asked for a 2-year lease, and I decided to sign a 1-year lease, provided that they will give me a 65 days notice renewal, which they did. And we have a 15-page lease agreement that was stated on number 86 on the respondent. So on page 9, we have a rider indicating the term of the renewal, which they exercise on a certain date, which they have complied. And on page 13 to 15, we have a guarantor signing this lease, which is notarized in the same time. So the lease was renewed. They sent us an email indicating that they want to release the lease. And if I did not renew the lease, I would have to pay them back the brokerage fee, which is around $3,500 some odd dollars. So they agreed to that. And that lease was signed on April 23rd on the renewal, and 2020. So, and we did send them a knowledge statement to the guarantor indicating there is a $50 increase to the lease, so which the guarantor has received. And they said this is, then they decided to back out on the lease agreement, saying that rejecting your lease on a certain date. And even though we have sent him multiple reminder telling him that the lease has already been renewed. And what the problem, I think, with the order is that they misread the acknowledge statement on the renewal, on the acknowledge statement on the $50 increase to the guarantor as a renewal form to the tenant, which is not correct. And I think the judge and the tenant decided to move to a different apartment because during 2020 there's a pandemic, and somebody offered them cheaper rent. They decided to leave.
So was there no obligation on your part to respond? Thank you. Respond to plaintiffs, respond to their statement that they were renewing the lease?
Yes, there's multiple. They did respond back to us. They want to renew the lease. That would be April 23rd, 2020. There's a renewal lease statement that they wanted to renew the lease.
Well, that's when Granite emailed stating that they were opting to renew the lease, right?
Yes, that's correct.
But did that not require some type of acknowledgement or further statement by you?
Yes, I follow up with a knowledge statement for the $50 increase. And then later on, there's multiple acknowledgements saying confirm that the lease was renewed on May 11 and May 10, and also April 30th, acknowledging that the statement has been accepted.
What about the initial request by you to inspect the apartment and their denial of that request, stating that I think the husband was, because of COVID, they didn't want anyone in the apartment because of the husband's condition?
First of all, they never sent me that statement. There is no condition that they prove that they have any condition at all. It was much later when, 6 months later, they presented us a letter which is really after the fact. There is no statement claiming that they were sick. Besides, this is done by another different person, not by myself. It's a loan depot, so they really are looking into refinancing a mortgage. Basically, they have the right to go in because they are a brokerage person, and they have the right to go into any apartment with masks and everything else. So they claim they can go in and out of that apartment in about 2 minutes, and ask them to wait downstairs in the lobby so they won't be affected, but they refused to let us in. But that wasn't done at all. So it was just a request, and nothing was done. Okay, so they rejected the lease on May 12th, which is much after the fact of April 23rd.
Yes, you have time on rebuttal. Thank you.
Okay. And they also default on the lease, by the way.
Your Honor, Your Honors, may it please the court, my name is Eric Granis, and I represent, obviously, the defendants.
Counsel, your client requested to renew the lease, but he never requested to renew the lease, correct?
My client
Your
requested.
clients
Yes,
requested it,
correct.
not their landlord, correct?
Correct. And really the moment I would respectfully, I do want to, by the way, note that Mr. Tong, although he is here pro se, he was represented vigorously by counsel down below. So I just want to note that because I know that can be of concern to the court. So I guess what I would really ask you to focus on is the date of April 29th, which is when they got this renewal lease, and recognize what a reasonable person, I think any person, would think is the situation on April 29th. So my clients have said, essentially, we would like to renew. Then
That was April 23rd, right?
Yeah, that was April 23rd. But
April 23rd, we'd like to
Right,
renew the,
right.
we
And on
are
April,
opting to renew our apartment lease from July 1, 2020 to June 30th, 2021.
correct. And I think that if that the landlord had written back at that point, we're done, that's great, that's a deal, then I think this would be a close case. I'm not saying my client would lose because there's a formal procedure set forth in the lease, but I think that would be a close case. But then Mr. Tong sends this form, and the form says, and you can look at page 6 of my brief, or you can look at page 73 of the record, it says he attaches, well, if you look at page 72 of the record, it says, attached is the lease renewal. Please sign and return a copy by email. Then the attachment says,
That's sent only to McLean,
right,
not to Granite. Is
Right.
there any significance to that?
I don't think so, and let me just finish this point, and then I'm going to return to that, which is that at this moment, Mr. Tong says, the owner hereby notifies you in the lease renewal form that your lease will terminate. So this is after April 23rd email.
So you're
And
saying
Mr.
that
Tong
that's
is saying-
inconsistent? That's
Sorry?
inconsistent with the notion that the option was accepted on the 23rd.
Correct. In other words, he's telling my clients, your lease is going to end. You have not renewed the lease. Now, my clients say, okay, you're telling me.
Then it goes on to say you may extend for 1 year at a new annual rent of $2,545, which Mr. Tong states was, he states that he said, okay, fine, but it's going to be an additional $50.
Right. And so my clients say, it's not the $50, but they're really troubled by this issue. One of them is immunocompromised, right? And they're saying, look, Mr. Tong is insisting he come into the apartment. This new apartment comes available. The convenient thing wasn't so much the cost. It was the fact that it was in the same building. So that, coincidentally, they saw it. So they were able to just take their furniture, I don't know exactly when they did it, but without encountering it, and move it into the new place. They had to pay an extra month's lease because the leases overlapped by a month. But this meant they didn't have to encounter anyone. They were free from the risk. And they're saying to themselves on April 20th, Mr. Tong is telling us the lease will terminate. So they go and renew the lease. And then after they renew the lease, No, I'm sorry, they don't renew. Then they sign a new lease. And after that, after they've relied on his statement, then he comes back and says, no. No, your lease is not going to terminate. You already renewed your lease, but we've entered into a new lease because you told us it would terminate. So they were, they had not renewed the lease legally. Everyone was in agreement that they had not renewed the lease legally, and Mr. Tong decided to change his legal interpretation after the fact, when at that point my client was already obligated on another lease. So it's patently unfair. And if I could just comment, there's so many cases where landlords have, unfortunately, because of the pandemic, have for months and years not gotten rent, and they can't evict somebody. And my clients paid every single penny that they owed him. In the end, the final month's rent was covered by the deposit. And I was astounded when I found out that this landlord who hadn't lost a penny was going after, these young people who are, students at the time in the medical field. So anyway, I have no more. Thank you.
I've never heard so much false statement there. First of all, it's specifically written on the lease saying deposit cannot be used as rent. So they defaulted on the rent. It's obvious, so they argue they pay every penny, which is false. You breach the lease agreement by not paying rent. So you cannot use the deposit as rent, as stated clearly on our lease agreement. There's a 15-page lease agreement that states that one of the paragraphs. And what he said about the lease renewal, we never sent him one. We never sent it to Jeffrey. We sent it to the guarantor. So his argument is false. So there is no renewal being sent to the tenant. So their argument is the tenant had the...
What do you make of your statement, your lease will end on June 30th? That's your statement, not theirs.
No, that's not a lease renewal. Lease renewal have a paragraph to...
I understand, but you send them a
It's an
notice that
acknowledgement.
say your lease will end on, that's inconsistent, 100% inconsistent with you've renewed the lease, right?
We never send them a renewal lease.
Right. So, but that's my question to you. How can you say that they renewed the lease by their email of April 23rd?
because on
when
our
on
statement,
April 29th, you say your lease will end.
Yes, there is a statement that we sent on the rider if they have informed us on the lease, indicating that the lease...
The rider requires you to inform them, not them to inform you. The way that the rider goes,
let me read up
I
the
have it right here. I have it as to you. The rider says
It's 104.
that the tenant must respond to the landlord. That means you have to offer it. You have to offer,
Oh, no,
and they
no.
have to respond.
Oh, no,
right?
you reading the same rider as I am? Or
I'm
does it sound-
reading rider to sublease 330 East 33rd Street, Part 4G.
Okay, you say tenant...
Anyway, okay.
You say here, tenants have the option to renew the lease for 1 year. To set the date, tenant must respond to landlord, no less than 65 days. So tenant must respond, not the landlord. And prior to the lease expiration are in good standing, and if owner don't renew, you got to pay him back $3,595. So the tenant must respond, not the landlord.
Thank you. Thank you both.
Thank you, Your Honor.
More Reason versus Manhattan College.
Good afternoon. May it please the court. Allison Snyder with Barry McTiernan and Moore for the defendant appellant, Manhattan College. The circumstances we're presented with here just cry out for striking the plaintiff's errata sheet. We've got a situation where the plaintiff was a native-born English speaker who demonstrated no difficulty understanding any of the questions presented to her. When she was initially asked how the accident happened, she gave a clear account. All of the follow-up answers that she provided were consistent. But then she provides
Well, I don't think that there was any statement that it was necessarily a language issue. I thought that the corrections dealt with, she didn't perhaps understand the question, or
No.
that there was an issue with the way the question was posed, or there was an issue with the reporter, and in terms of reporting it, but what is stated in the transcript.
Your
That
Honor,
it was an error.
Your Honor, well, what I was attempting to say is that normally we have a situation where there can be some sort of gray area over whether or not there was a transcription error, whether or not the deponent misunderstood the questioning. That's not the situation here. We're talking about 17 corrections out of over 6 pages of testimony dealing with liability out of a 118-page transcript. 8 of the 17 are transcription errors.
No,
Now,
look, but counsel, even if we assume yes, why isn't it sufficient to allow you to depose her as to why she made those edits? That's all going to go in at trial, and if you have an issue, then you can cross-examine her.
Your Honor, it's my understanding that that rationale presumes that the standard is whether or not the party that is seeking to strike the errata sheet is prejudiced in any way. That's not what the standard is.
No, the
standard
question is whether it was an abuse of discretion to give you this form of relief rather than striking the errata sheet. That's what we are here to decide.
In all of the cases, and I just wanted to direct the court's attention to Smith versus Costco. Now, that's a 2008 case in this court. Exact same situation where the plaintiff slipped and fell, claimed that she didn't see what she slipped on, didn't see the liquid. She assumed it was liquid because it was wet. She then later tried to backtrack on that and in her errata sheet, go ahead and give a different explanation. The court said, look, we're not going to be bound by that. There's here, here as in that case, the plaintiff didn't actually try to distinguish that in any way. There's no harm to striking this and allowing the plaintiff to go ahead and submit an affidavit at some later point that goes ahead and makes the same variance that she tries to do in the errata sheet here. But the standard under 3116 is that, and this court and other appellate divisions have been very consistent that when you're trying to make a substantive change to material testimony, you have to give a sufficient explanation. A one-word example, a one-word clarification is not sufficient. What was the plaintiff clarifying? What she was saying here, and I don't know that if we did a good job of saying this in our brief, is that she's also making deletions.
I understand you say that the test is not prejudice, and I'm not disagreeing with that, but to the extent that one would consider prejudice, does the further EBT that you've been granted eliminate prejudice?
Well, I'm a little confused why you're talking about prejudice at all. Where does prejudice come into this? The issue is whether or not it's a material change to her testimony. I'm a little confused why prejudice is given any consideration at all. It's the plaintiff who has to show good cause for the change, and
Well, you had 2 requests for relief below, did you not? Wasn't your alternative request a further EBT?
yes, but that didn't give us full relief. We're actually trying to strike these changes. The plaintiff can go ahead and at any point she can submit an affidavit. She can give further testimony.
Let's be clear. The fact that there are substantive changes doesn't in and of itself require striking the errata sheet. It's only sort of situations where there's a change in the theory of the case or something like that. There's no change. I mean, the theory of this case has always been that she slipped on something
Except that the material change is to whether or not she was the source of the liquid. She initially said, I would just dump all the trash into a plastic bag and I put that in my bin, and that bin, everything in my bin went into the dumpster. Now, she's saying that she separated out all of these liquids and put them in a separate chute. The chute, that isn't, she never said that. Out of 118 pages, she never said she put it in a separate chute. It goes from being, I dumped everything into the dumpster, to I separated things out. That goes to her. That goes to her comparative negligence or her comparative fault. That is a change. She quite clearly said that I didn't separate anything, and now it's I separated something.
You think that's a change in the theory of the case? I'm sorry.
Absolutely. It absolutely is. She was asked directly, did you separate any of that out? And she said no. But after conferencing with her, apparently with her attorney, suddenly anything that even hedges as to whether or not she either saw the condition before or she was responsible for creating the condition, that changes. And the deletions are relevant here too. She takes out any qualifying language, and that's what's going to be before the court when it comes to deciding a dispositive motion.
Thank you. You have time on rebuttal.
Good afternoon, Your Honors. Russell McHugh, Michael S. Lamonsoff's office for the respondent plaintiff. In this case, it's a case truly of trial courts.
These changes go beyond insubstantial. I mean, these were substantial changes that she made as to how the cause of her fall may have come about.
I don't believe they are substantive changes. In fact, I think they're clarifications of questions not asked. To the extent that there were clarifications as to how garbage got into the bin. This has always been a case.
Taking up the last point that your colleague mentioned about separating out the liquid, whether throwing everything into the chute or separating it out, that's not a substantial change in testimony?
It's not a substantial change in the theory of the case, in the theory of liability in this case, which has always been slipping on a slippery substance, and that was added. Now,
but where it may have come from is a significant factor in the case, is it not? And isn't it a significant factor as to how comparative negligence may be calculated?
And that is certainly something that would be brought up on a deposition that the defendants asked for in their relief and obtained from the trial court.
It's true that they asked for it, but because they put in a fallback position so that they don't get completely thrown out on this, shouldn't mean that they don't get relief on their first request if it's otherwise warranted.
The manner in which the materials got into the bin is the only thing that was changed. And it was changed to the effect that instead of she clarified that it went into a chute into the bin rather than just directly into the bin. So I don't believe that's a material change or substantive change. It's a clarification of her testimony.
Well, what's her role in it getting into the bin or into the chute? Where is she in this?
I'm sorry?
Where is she in this change and as to where the liquids may have been thrown?
Where is she?
Yeah, what's her role?
Her role is getting the materials into the bin. The fact that
I mean, but just calling it a clarification, what needed to be clarified? There's no need to clarify. What she said was, I put all the garbage in a bag and threw it in the bin. And then the clarification is, oh no, I put some in this bag and then put the liquid in another. That's not a clarification. That's a completely different answer.
Absolutely, and you know what? Substantive changes are allowed on the 31, was it 16? That absolutely allowed, and this is a clarification of the way the materials got into the bin. The stuff got into the bin one way or the other, but this is just a clarification of that. It's not a material change in the theory of the case.
You don't think it's a material change to say, I may have spilled the liquid that caused me to fall, as opposed to the liquid was on the ground? Doesn't that go to notice? Doesn't that go to duty? You don't think that those are important parts of your case?
I think they are, but to the extent that the way the materials got into the bin and whether they were bagged before or after, I don't believe changes any of the theories in the case. And I believe, again, in the judge's discretion in reviewing the errata sheet, This is not an abuse of discretion to allow the remedy that's been provided
Well, if it's
for
a
the deposition.
substantive change, it is an abuse of discretion.
I'm sorry?
If he's allowing substantive changes to be made, that is an abuse of discretion. It's not just a discretionary matter to say, I'm allowing you to make a substantive change in your EBT.
Substantive changes are explicitly provided to be allowed under the statute. So whether there is good cause or a good reason for the change, for the clarifications, that's a different story. But whether substantive changes can be made is certainly allowed under the statute. So to the extent that the plaintiff had good cause for the delay in the errata sheet, that the judge properly exercised discretion, provided a remedy that was requested by the defendants, and that these are not material changes in the theory of the case, the errata sheet should be allowed to stand. I thank you for your time and your patience with me.
Thank you.
Thank you. Just briefly, what I wanted to comment on was that, these, the one-word justification for any of these changes, it's mere pretext. The plaintiff, if he had, or the plaintiff, if she had serious concerns about the transcription errors, she could have brought a motion to suppress under 3116E. But that, of course, would have placed the burden on the plaintiff to prove that the transcription errors were inaccurate. That's something the plaintiff simply cannot do. The plaintiff ended up excising certain adverse testimony, such as she said it happened so fast that she didn't see what was on the ground. That just came out, and she attributed it to the court reporter. Also, adding words in there, it's certainly incredible that the court reporter would have missed the same phrase
So let me
twice.
just ask you, after this deposition, you can go back to the trial judge and ask again for the errata sheet to be struck, right? If she can't explain adequately explain the clarifications or why the court reporter got it.
But we did exactly that. The plaintiff served the errata sheet. We did what we had to do, which was to strike that.
I'm asking after the deposition that you've been allowed, you're looking at me like I have 8 heads. You get a deposition, right? You're getting a deposition to have her explain her changes, correct?
Yes.
Is there anything after that deposition that would prevent you to go back to the court with the results of that deposition and show the judge, make this a more sort of detailed and descriptive argument about the errata sheet?
That's not before this court. What's before this court is
I
literally-
understand what's before me, Alice. I'm asking you whether that is not an avenue for you.
It's an avenue, but it's not at issue.
Is there reason to think you're going to get relief of that nature in the face of the decision that Supreme Court has already made?
No, in fact, the court didn't give any reason why they didn't strike it in the first place.
What exact use would this further deposition, I mean, what do you do with it? The point of the deposition is what use you may want to make of it in front of the jury. I mean, what sort of a situation? Are you going to have the original deposition, the errata sheet, and a new deposition? I mean, it's rather cumbersome to consider what you're faced with presenting to a jury if this case comes to trial, isn't it?
I agree. And I just have to say the one thing that I really think is opening the door here is this court is apparently, at least from the questionings, apparently seems to sanction a plaintiff just simply saying, the court reporter was wrong. That's not what I said. This is what I truly meant, and I meant, eventually opening the door so that she can come forward with an affidavit later that says, okay, I didn't really recall what was in my bin, but that means that it certainly was possible that there was no liquid there. So they've completely
It's never a
changed.
good thing. It's never a good practice to draw any conclusions from questions posed by the panel.
I agree.
But thank you both for your time. We really appreciate it.
Thank you.
Began v. Aono Break Corporation. Justice Friedman is recused on that matter.
Good afternoon, Your Honors, and may it please the court. My name is Heather Janice Gaw. I'm with the law firm of Siegel McCambridge, Singer and Mahoney, and I represent the appellants. At its simplest, this case involves American Honda and Nissan North America, two non-domestic corporations sued in the state of New York without any evidence of asbestos exposure from their products in this state. Any inference of exposure offered by the respondent is wholly speculative and at best brief.
Well, they are doing business here in New York in that there are auto dealerships, which the decedent apparently trained at during a period of time. He did training there, and during another period of time visited. Is that correct?
So the decedent lived in the state of New York until 1976, and at his deposition, he never once alleged exposure from products from either of my clients during that period of time. The later period of time was after he started his business, Street Smart, which started in 1989. This business marketed a certified pre-owned vehicle sales plan. He would travel the country and Canada to sell this plan to dealerships. He never had an agreement with my clients or a contract for this plan.
Was there not?
Rather,
Did he not engage in training at some of the auto dealerships between 1970 and 1981?
that in the state of Florida, he worked at multiple automobile dealerships where he alleged exposure from a variety of products, including my client's products, in the state of Florida, but not in the state of New York. The only later contact in the state of New York that's being alleged are more than one, and this is from his testimony, visit to an independent and unidentified Nissan dealership and a single independent and unidentified Honda dealership where he would spend the day marketing his sales plan for them to purchase it.
And that was between,
In the 1990s.
in the 1990s, okay.
Yes. So in the 1990s, he would go to these dealerships marketing a plan. During this time, he would spend 45 minutes to an hour in the service area, but during that time, he never once identified either the vehicles that were in his presence or the parts that were in his presence, nor did he allege exposure to asbestos from any vehicles or
Well,
parts.
so it's your burden, right? So did you allege that at that period of time in those days that there could not have been, did you put in any evidence to show that your asbestos breaks couldn't have been in those? It's not the plaintiff's burden to do anything. You're seeking to dismiss the complaint. So you've got to show there's no possibility that he was exposed to asbestos. So assuming that he did say at some point, I was in the 90s, I was in these training areas with asbestos breaks, what did you put in to show that that couldn't have been true?
This was not a summary judgment decision on terms
Again,
of causation.
I'm just asking you, what did you put in to show that that could not be true?
But respectfully, it is the respondent's burden to provide sufficient evidence to prove jurisdiction in the state of New York, which has
So
not been done.
under A3, I got exposed to the toxic substance in your auto dealership in New York, and you derive substantial income. And you don't dispute that you are here in New York. There's no dispute about that. The only thing you say is it's not enough that he said he says I was in my dealership, I was in your dealership showing your people what to do in areas that contained asbestos. I breathed it in along with many other things. This is a toxic tort case. And have we ever said that's not enough?
There is no evidence in the record or testimony in the record of the work that was performed in his presence at the Nissan or the Honda dealerships in New York. There is no testimony in the record as to the vehicles he worked on. These could have been any other number of vehicles. Again, it's a used dealership plan that he's marketing. There's no testimony or evidence that of the specific vehicles, the specific work, the specific parts. Him just being present in a dealership.
Where asbestos breaks are being worked on, and you don't deny that.
Well, to be fair, in the 1990s, asbestos is not ubiquitous. There was no defined time or location when he made these visits. Could have been in 1999. This was at a time where there was no evidence in the record to support exposure in New York.
But we're only talking about a sufficient to show that you should not be shocked at being sued here. That's it. You're certainly free to argue to a jury everything that you've just said right now, But the question is that enough that you should not be, your due process should not be violated by being brought into court here in New York on that?
Your Honor, in fact, our due process is violated by being brought into New York on that, because as an act of interstate federalism, Florida was the forum with a greater interest and more interest in the controversies in this case, with over a decade of exposures versus at minimum 3 visits with speculative exposure to try to bring in a case against my clients with personal jurisdiction.
Thank you.
3 visits.
Good afternoon. Sam Ellswick on behalf of the respondents.
So what about the argument made by your friend that there's no showing, you make no showing that there was asbestos at those plants in the 1990s, at those dealerships rather, in the 1990s?
Well, of course, we made showing that there was. In fact, asbestos depositions with respect to malignant mesothelioma, which my client had, are very different than depositions that are performed that most are part of.
Did your client testify that there was that asbestos-containing breaks
Yes, he
were
did.
being worked on at those places when he was there?
And what I was going to say is that previously in his deposition, these depositions aren't straightforward. You don't have,
I worked in an asbestos
Okay.
part. We don't need.
So
we
is
just
it-
don't
testified
So is the
that when
answer
he was at
you
Street
did?
Mart and he was performing consulting work and training work in dealerships as part of his certified use pre-owned program that he was training dealerships on, that he was exposed to asbestos during these training programs.
And that
that's
is
at-
because there was work being done or being conducted at those dealerships when he was there.
That, and also, I think it's at record 241 to 243. Yes, and he said that while I was in the service bays, these vehicles would be put on lifts, put up all 4 wheels off, and I would go through training on the brakes and show the mechanics what we would need to inspect and what we would need to change. And during the deposition, during the lead examiner's questioning, he said, yes, I was exposed to asbestos during these training sessions. Later on, when he testifies, he says, yes, I was at 2 Nissan dealerships at least, and a Honda dealership in New York when I spent between 45 minutes to an hour and a half each in the service bays while, again, the vehicles were put on lifts, brought into the air, wheels off, and he showed them how to train through these vehicles. With respect to asbestos in their products, Your Honor is exactly correct. Defendants provided no evidence there was asbestos in their products, but in fact, plaintiffs provided record evidence. First of all, through John Began's testimony that he believed it contained asbestos, and second of all, through the testimony of one of their employees that actually said, yeah, asbestos was in their products in the 90s, and their own interrogatory, that was Honda, and Nissan's own interrogatories that said, yes, there was asbestos in their products.
And there was nothing no affidavit or anything else from them stating that the work was not being conducted at that time.
And that's a very good point, because if you look at the lower court's opinion, the judge brought attention to that. It says, well, they've provided no evidence that says there wasn't asbestos in their product, there wasn't asbestos in these dealerships, there wasn't asbestos on these vehicles' brakes, but plaintiff has provided evidence that he was in the bays, that he was exposed to asbestos, and that asbestos was in their products because of the interrogatories and, again, the testimony of their own witness. And I will say the court was correct on purposeful availment. There's no question. Both defendants have admitted to purposefully availing themselves of the privileges and protections of conducting activities in New York. So then we get to arise from or relate to. Does this arise from or relate to? Of course. We have an injury in New York caused by products that are shipped into New York that causes injury to a person in New York. That's what we have under the long-arm statute. Then we're in due process. And then the court was right to ask. And I believe in the Ford opinion, Justice Alito in his concurrence asked the same thing. He said, with respect to Ford, can anyone reasonably argue that requiring Ford to litigate this case in it would be Minnesota or Montana, be fundamentally unfair? And I would say that same question that Your Honor asked is exactly correct. Can anyone reasonably argue that requiring Honda and Nissan to litigate this case in the state of New York would be fundamentally unfair? And the answer is, of course, no.
Unless there was zero evidence or really nothing showing that the plaintiff was exposed to asbestos from those two companies. And it might be not the biggest amount of evidence, but your point is there is at least some.
And we're at, the genuine issue of material fact. Could the judge, is there a genuine issue of material fact? You have plaintiffs saying, I was. You have testimony that he was there. And then you have the evidence that we put in the record, which was, of course, their employees saying, yes, there was asbestos in our products, and the interrogatories that were saying, yes, there was asbestos in our brake products. So I think all things being considered, in all fairness, certainly, and we look at, we drop down to the second part of looking at due process, and we say, on the interstate judicial side of it, would it be more expeditious to ship half this law, not even half. Most of the defendants we've sued are New York defendants in New York state courts. So would it be correct to ship this off to Florida, this part of the litigation, and piecemeal it out? And if we look at the burdens under Asahi, the 5-factor burden test, the burden on the defendant's light. They're both United States corporations. They both ship into the state of New York. They sell into the state of New York. And so, Your Honor, I see my time is up, so I'll conclude and say I would ask that the court affirm the lower court's decision and put this case back in the state court where it can be tried and finished. Thank you.
Just to respond to some points briefly, my colleague raised the Ford v. Montana case. That case specifically held that the law of specific jurisdiction seeks to ensure that states with little legitimate interest do not encroach upon states that are more affected by the controversy, in this case, the state of Florida. To raise the testimony to Your Honor's attention on the record on page 626, when asked about the work performed at the unidentified, and again, independent Nissan dealership. These are dealerships that are independently owned. When asked what work was performed in your presence, I cannot recall. With regards to the Honda dealership, and again, this was a single visit to a dealership in New York sometime in the 1990s. Do you remember a make or model of a Honda that you encountered? Or, sorry, you can't recall any specific make or model of a Honda that you encountered at that dealership on that one day. Is that correct? Correct. So while he may have been present in these dealerships, he cannot identify any vehicle or part sold or distributed by my clients. Other parts may have been in his presence. My colleague raised testimony from Lead indicating what would happen during visits, but this was general testimony about any of the visits he would have made to dealerships across the country and in Canada. But when asked about the more than one, which is the testimony, Nissan dealership or the single Honda dealership, he could not identify the work or the parts or the cars. So he cannot allege asbestos exposure from my client's products in
Well,
this
how
state.
do you deal with counsel's statement that your clients all admitted that their cars had asbestos in the 90s at the time where plaintiff was in the dealerships with them?
The general allegation that there is asbestos in products is fine.
We've never
That
had
does
to
not-
say you have to pick valve number 1207. That's never been the test. And you couldn't find a state or federal case to say that.
I appreciate that, Your Honor, but without an injury in the state, and an injury being the inhalation of fibers or the exposure of asbestos in the state of New York, you cannot reach personal jurisdiction under 30201A3.
Except the plaintiff has testified that he was injured, that he did breathe it in the Honda and Nissan dealerships, and you haven't disputed that.
We have disputed that. There is evidence in the record that he cannot recall the parts, vehicles, and just because he was present in the dealership does not mean he was exposed to my client's products. I could have gone to those dealerships, but without saying the work performed in front of me or the parts being used, I cannot allege asbestos exposure enough to support personal jurisdiction.
Thank you. Thank you both.
Thank you.
Magnan versus Watsky and Dam.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff appellant. I think this case is essentially governed by the Court of Appeals decision in Gronsky and how you interpret that decision as applied to the facts of this case. I'll concede to you flat out that the Court of Appeals in Gronsky did say they weren't dealing with a lease, they were dealing with an agreement, but the analysis was the same, and they cited to Rideau against Goldberg, which, as you know, is a lease case. I didn't write the brief, so I can brag for the plaintiff.
But you were on Pena 1, right?
Excuse me?
Weren't you on the prior appeal?
I'm just arguing this for the attorney. I wasn't on it. But to give the attorney her due, she did something that I thought was very, very interesting and quite frankly, very, very smart. She compared the Cheapy's Inc. lease with the one-page lease that the plaintiff's employer had. And it's actually interesting. The one-page lease on 1733 of the record, as you know, talks about snow removal. If you look at the Cheapy's lease on the first page and on the 8th page, it talks about remediation, actual snow and ice remediation. We don't have any remediation duties here. So to me, there is even a question of fact with respect to the way in which the lease was worded. But we have testimony here that I think under Gronsky absolutely establishes that at the very least, the defendant owner is not an out-of-possession landlord as a matter of law. And let me give you the pages because I know it's a huge record. Mr. Dam himself stated, this is on 565 to 568, that he keeps a snowblower and a, quote, quad that has a plow on it at the property, close quote, and he makes a point of going to the property whenever there's a snowfall to, quote, make sure that the snow is removed and the areas are clean. That's 565 to 568. Mr. Wooster, who is the principal of the co-tenant, he said this on 1550 to 1551. And again, I'm quoting. This isn't me making an argument. This is from the record. Anytime it snows, Jim, that's Jim Dam, he's the owner, is always at the property, sometimes thereafter to clean up snow removal on his own. He then goes on to say on 1583 to 1584, again, all quotes, Mr. Dam, quote, would always salt the property. Jim has a UTV with a salter on the back, so he would drive around with his UTV with the salter on the back and salt the place. And finally, on 1512, he said that Mr. Dam, quote, has been more active on the snow plowing. You see him on a UTV with a snowplow on its kind of running around, throwing salt down, which is something he has never done, 1512. Finally, Mr. Caparizzo, and this is on 3288 and 3289, was asked this question, quote, did you ever observe anyone else shoveling the parking lot himself? To which he responded, quote, the owner, he has jerry-rigged something to push it. He has like a push mobile to move the snow. And in response to the second question, when you say the only one you're referring to is Mr. Dam, Caparizzo says, quote, yes, he is the only one that I've ever seen in the parking lot to clear snow. If you look at the Gronsky case, there's zero question, and the Court of Appeals actually said it in the decision, that the waste management company that was running the recycling plant had exclusive responsibility to run it, to maintain it, to repair it. As I read that decision, the Court of Appeals said there was a question of fact as to control for 3 reasons. 1, the county had the ability to stop people from coming in. 2, the county had the ability to do tours. I never thought tours were that important, but apparently the Court of Appeals did. And 3, and finally, at the end of every year, there was a management agreement that the county could talk about and could work with Metro Waste about. That involvement is far more substantial than far less substantial than the owner's involvement here.
What does the contract state, and what is the relationship between Beach LLC and AIC?
I'm sorry?
What is the relationship between Beach LLC and Beach Logistics, LLC and AIC?
Well, I think the owner here, the admitted owner is, I'm sorry, just let me get the name. There's no question that the owner is Watsky and Dam, Inc. So they're the owner. That's the only one we're looking to come in on that, and those are the 2 leases. So they're the owner. Mr. Dam absolutely gave the testimony that I gave, and that's the issue. The issue is vis-a-vis his assertion, accepted by the trial court,
Right.
that he was an out-of-possession landlord. So The way I read
Well,
Gronsky.
no. What about BBB saying it was our responsibility?
no.
Come on, everybody,
Absolutely.
except for you, everyone agrees that it was BBB who had the responsibility.
100%. I'm not saying, look, I'm not saying that this is a 240 subdivision 1 labeler case, and I'm not saying that Mr. Caparizzo didn't say it was our responsibility, and I'm also not saying that Mr. Dam didn't say it. He said it too. He said, I don't have to do anything with respect to those spots. That's exactly the same argument that the county made in Gronsky. The fact that someone else might be responsible doesn't mean that the owner is an out-of-possession owner as a matter of law, and this is a summary judgment motion. So you have to give me the most basic construction of the evidence favorable to me that you can, and I tried to read to you the actual quotes from the witnesses about what
They
happened.
were on the property for 7 days, right?
Yes.
During that 7-day period of time, did anyone see the owner come and clean up their spots?
The test during that time,
Yeah,
the answer
that's it.
No, I know. The answer is no.
So
during
at the
that
moment of the lease, when BBB said, I am responsible for this, till the date of the accident, there's zero evidence that the owner did anything to abrogate that responsibility, correct?
Yes, but Mr. Worcester's testimony, and he was there for 10 years, didn't deal just with that 10-day time period. So he said that in the past, he saw
In the
Mr.
past
Dam
doesn't
doing-
matter when you have a lease that's entered into on that date. Maybe in the past, different things happen, but on that date, that's when the responsibility became BBB's, correct?
I'm not saying BBB. I'm sorry, my time's up. Can I just answer
Please.
Judge Scarpello? Again, Judge Scarpello, I'm not saying that BBB, that the owner was not, that the employer was not necessarily responsible. All I'm saying is that in Gronsky, they made that exact claim. The county made the same claim. We have no responsibility. We gave the entire recycling plant to an entity, and the court said because of the rights that they had, there was a question of fact. That's all.
During the period of time that the lease was in effect, correct? Not 10 years before, not 20 years before, at the time. Are we in agreement?
I am, but this lease was in effect, and again, the Cheapy's lease, they had responsibilities that were very, very similar to the responsibilities of BBB, and despite the fact that they didn't have a responsibility to actually do it, Mr. Dam did it. So the question of...
Does that mean, because Mr. Dam did it, does that obviate the fact that it states that BBB is responsible for the snow removal?
No, but the Gronsky court said that the fact that you have an agreement is not dispositive. You have to look at the entirety of the situation, and you have to look at the party's course of conduct. And I'm not going to go over my time. I'll actually read you the quote when I stand
Thank
back
you.
up.
Good afternoon, Your Honors. May it please the Court, Nicole Duke from Correa Conway and Stiefel for defendant respondent. Here, it is obvious that defendant respondent was an out-of-possession landlord. There was a clear lease agreement between the defendant respondent and Bark Bathe and Beyond that the 4 spaces in the parking lot were leased to Bark Bathe and Beyond solely for their duty to maintain the parking spots, to clear
But there
the snow
was
and ice.
testimony that they would clear the snow, there would be snow removal, including for those 4 spots that BBB had, if in fact they were open, right? That they would also remove the snow. Is that correct?
In the lease agreement, the absolute duty is just to Bark Bathe and Beyond, and turning to right of re-entry, it has been held in this court before that an out-of-possession landlord with a general right of re-entry is not liable for general maintenance.
Well, out of possession, but I mean, I think my recollection is he had an office there. Didn't he maintain an office there? He would also go to the premises when there was a snow condition or some type of precipitation or something of that nature. And again, was there not testimony as to the maintaining costs in the lease agreement because of, maintaining this tenant? They would, and other tenants, they would also include snow removal?
At least for Bark Bathe and Beyond, the lease had begun about 10 days prior to the accident. The plaintiff does bring up arguments about Mr. Cheapy's lease, and Mr. Cheapy's lease has nothing to do with Bark Bathe and Beyond's. There was no testimony that in the time period from when this lease began with Bark Bathe and Beyond, 10 days prior, that the defendant respondent had gone onto the property and done any kind of maintenance work. Further, as an out-of-possession landlord, unless there was some kind of structural failure, they are not liable. And here, it clearly was just a condition that was created by a snowstorm the day before, which was submitted by plaintiff, the weather report. Plaintiff further makes an argument that in some way, defendant respondent created this condition, but provides no evidence to that at all. By submitting the weather report, actually, it shows that there was a snow and ice storm the day before, and there is no evidence besides some testimony from an office manager saying that there were some structural issues with the building, but that is not an engineer, that is not an expert report, and nothing was submitted to that effect.
Did the plaintiff submit anything to show that Dam actually cleared their parking space at any point?
Not in the time period from Bathed and Beyond's lease beginning until the date of the accident, no.
Their vehicles were parked in those spots, weren't they?
Yes, Bathed and Beyond's vehicles were parked in that spot, and in fact, the plaintiff was on duty at work and walking over to that vehicle or coming out of the vehicle when she slipped and fell.
Just as a practical matter, how would have Old Albany been able to clean it?
I apologize, I couldn't.
How would have Old Albany been able to clean it?
They would not have been able to access that at that point. Defendant responded as, again, it was the plaintiff's duty at that point to clear the space. The plaintiff's company, Bathed and Beyond, she was on duty at work. The van was in the spot, and in no way could the defendant respondent have accessed that parking spot, even if they had some duty to maintain it, which they did not.
And the owner was there, BB's owners was there, and
Yes,
witnessed the accident.
Correct. And the owner, Mr. Caparizzo himself, said that it was solely Bathed and Beyond's responsibility from his understanding of the lease to clear that spot. And there's no disagreement to that on either side. And thank you, Your Honors.
Ms. Isaacs, I apologize. You're on the other case, Pena.
Yes.
As well, which is another slip and fall case.
That's okay. I forget the cases also, so it doesn't
Yeah,
matter.
you're on so many of them. I see your name on so many cases. I forget.
Yeah, they kind of meld into one another.
Yeah.
Judge Skospapula and Judge Weber, this is the quote I wanted to read to you from Gronsky. I'm reading. It's 18 New York 3rd at 380 to 381, verbatim. Thus it follows that when a landowner and one in actual possession have committed their rights and obligations with regard to the property to a writing, we look not only to the terms of the agreement, but to the parties' course of conduct, including but not limited to the landowner's ability to access the premises, to determine whether the landowner in fact surrendered control over the property such that the landowner's duty is extinguished as a matter of law. And in the very next sentence, the Court of Appeals said this, again, I'm quoting, in this case, the agreement between the county and Metro Waste unambiguously assigned the responsibility to implement safe practices and to remedy unsafe conditions at the recycling center to Metro Waste. Despite those clauses, the Court of Appeals, reversing the trial court and the appellate division, said there was a question of fact as to control. And Judge Friedman, you brought up a point about the parking of the vehicles. Can I refer you to page 3575 of the record? That's the aerial view. There's a couple of them, but that's probably the clearest photo. At the time, my recollection is that my client was the only one who was present. The other vehicles had gone. She was the only one who was there. And if you look at that photo, she walked out the passenger side to the right. So it was not infeasible, as a matter of fact, or as a matter of law, for someone to have cleaned the area.
But wasn't the owner there at the time, and couldn't he have cleaned it?
The owner was there, and in fact, the testimony is undisputed. It's a sheet of ice, right? So everyone says it's a sheet of ice. The owner actually gave a warning to Caparizzo, who's the principal of BB&B, says, hey, it's really slippery, be careful. But
But that's who the just, she's asking, couldn't the person responsible for it have done it right then?
He was there, right?
I am absolutely not saying that someone else isn't responsible. All I'm saying is that just because one person is responsible doesn't mean that you can't have 2, 3, or 4 people responsible on the ground. You can have multiple proximate causes of an accident. Thanks.
Thank you. Pena versus American Industries.
Good afternoon, Your Honors. Kevin Fitzpatrick for defendant appellant Greg Beach Logistics. May it please the court. We request that the lower court's decision denying the motion to dismiss for failure to join necessary party Jerome be reversed. The lower court's decision stated that the argument lacks merit because AIC seeks contractual indemnification from breach of contract, contractual indemnification, which does not include Jerome. However, Your Honors, the action by AIC as against my client Beach is really negligence, sounding in negligence, because the contract between AIC and Beach provides for indemnification only arising out of the negligent acts or omissions. That's what Beach wrote into the contract. So that's the trigger. And the lower court, in the prior summary judgment decision by Judge Kalish, denied summary judgment on indemnification because there were questions of fact about the negligence of Beach and also the negligence of AIC.
So this was my question to Mr. Isaac on the last case, because he was on the first Pena case. In the contract between Beach and AIC, does it specifically state that there has to be some type of negligence?
Yes.
And where does it specifically state?
That's what was written in. The original language was crossed out and changed by Beach to negligent acts or omissions. So the cause of action, although it's contractual indemnification, is really negligence. Also, the lower court decision overlooked that AIC had previously moved for summary judgment on common law indemnification as against Beach. And that would, of course, require, in order for AIC to prevail.
So your position, correct me if I'm wrong, you represent Beach and you say AIC is going after us, but really they should be also going after Jerome.
Yes.
So when you get to trial of this case, is there any, and you're saying that we should dismiss it because they failed to bring in Jerome. When you get to trial of the case, is there something which would stop you from pointing the finger at Jerome and saying to the fact finder, we're not responsible for this, this is Jerome's fault?
I suppose not, Your Honor, but the lower court found that Jerome would not be on the verdict sheet. So if the jury...
Would that stop you from arguing we had nothing, we're not the cause of the occurrence, it's Jerome?
Well, the jury will be precluded from apportioning any fault to Jerome on the verdict sheet, and Jerome won't be there.
That's because of the workers' comp?
That's because of workers' comp, because
There was a determination as to
there's no grave injury and we didn't have a written agreement with them.
Right.
So any negligence of Jerome is potentially not the negligence of Beach. And there is evidence in the record of negligence on the part of Jerome as the employer, director, controlling, supervising plaintiff's work, operating the scaffold. In fact, Judge Kalish referenced how the plaintiff made a complaint prior to the incident to his foreman who worked for Jerome, which is evidence of notice. So there is evidence of negligence on the part of Jerome, and my client, Beach, will be prejudiced without having Jerome in the lawsuit for the jury to consider their negligence. And I would like to draw a distinction to a case that was heard in this court, Hilton 220 AD 3D 443, which dealt with similar issues where the court affirmed the lower court's decision not to dismiss for failure to join a necessary party because they said there was no factual basis to assert a claim against Condé Nast. It was an elevator case. And they said that there was no evidence that non-joinder would prevent the parties from obtaining full relief. And they said that the party seeking dismissal couldn't plead the other party, which we obviously can't do here. Beach cannot implead the employer due to the workers' compensation bar, and it's different because there is evidence of negligence on the part of Jerome, unlike Hilton. Unless Your Honors have any further questions, thank you for your time.
Thank you.
Good afternoon, Your Honor. Michael Marone, McElroy Deutsch, Mulvaney and Carpenter here on behalf of AIC. The discrete issue before the court is, and I go to Your Honor's question, not whether Jerome can be blamed or other parties can be blamed. The issue before this court is whether Jerome is a necessary party, without whom complete relief will be deprived of Beach.
Well, doesn't he have a good, or at least certainly a decent answer to that question? If Beach is not liable to the extent Jerome is negligent and it's not on the verdict sheet, how does Beach at trial protect itself from being held liable for Jerome's negligence?
Well, the starting point is whether Jerome, they can be blamed. But with respect to CPLR 1001A, we look to complete relief, whether Beach can have complete relief without Jerome, and they can. And the trial court was correct because they noted that to be a necessary party,
So how do they have
that
complete?
necessary party must
So how do they have complete relief if they're not responsible for Jerome's negligence, and let's say Jerome was negligent, and that's not presented to the jury, and the jury is not given an opportunity to ascribe a portion of fault to Jerome?
They can't apportion to Jerome because they're a non-party who under 1601...
But that's his point, they belonged in.
Well, first, they have to be someone that will deprive complete relief to Beach. And what the trial court said was Beach is entitled to no relief from Jerome. They have no contract with Jerome. They have no right.
And is there anything stopping Beach from arguing that it was all Jerome's fault, even though Jerome isn't on the verdict sheet?
No, there's nothing stopping them, Your Honor.
Right?
And they can
There are
do that
plenty
all
of
day long.
situations where someone says, wasn't me, was someone non-party, a non-litigant, right? There's nothing weird or unusual about a party seeking to put liability on a party that's not, on someone who's not a party to the action, right?
That's right, and they can't
There's no
have it on the
requirement that
verdict
the
sheet either,
person
though.
be on the verdict sheet, right?
Yeah.
So it's true what you say, let's grant you that Beach is entitled to nothing from Jerome, but why isn't Beach entitled to diminish what AIC can recover based upon what Jerome did?
The express language of CPLR 1601 that says where there is an employer where there's no grave injury involved, there can be no allocation against a non-party in that circumstance under 1601. And what Beach is arguing is they're trying to force AIC to pursue a contract action that we don't want to pursue.
Is it relevant that it was the main action was discontinued as to Beach by stipulation?
I'm sorry, Your Honor.
There was a stipulation discontinuing in the main action, discontinued as to Beach, right?
Yes, it was discontinued as to Beach. They were a direct defendant, and when the trial court ruled on 240 sub 1 that we were strictly liable.
And then you settled. It was settled as to Beach.
Reverse bifurcated, then we went to damages. But my point, Your Honor, is that they can blame Jerome all day long. They can seek an allocation against settled parties, not Jerome as a non-party. The only way Jerome ever comes into this case, if we are forced to pursue a contractual indemnity claim against it, that's the only way we have a cause of action against it. And that just simply is not sanctioned at all by CPLR 1001A or B or CPLR 1601.
Thank you.
Thank you.
Your Honors,
He says that you're not entitled to an allocation against Jerome because of workman's comp.
Beach cannot sue for contribution.
But he just said is that you're not even entitled, that you cannot ask the jury to allocate fault to Jerome because of the workman's compensation law. I mean, that's what he just quoted the CPAN. He's shaking his head yes, so I'm not making it up. That's what he just said.
I know he said that, and I was going to address that because my question is why not? If AIC...
He says that's what the CPLR says.
Well, I disagree because if AIC is, assuming arguendo, suing Jerome and Beach in a lawsuit, the jury will then have the opportunity to apportion fault to Jerome. AIC is asking for indemnification for what we're saying is the negligence of another party, which is prohibited by the general obligations.
Okay, so he said there's nothing to stop you from blaming Jerome in front of the jury. And your comeback to that is but it's not going to be on the verdict sheet, so there's not going to be out. But he says you're not entitled to have that on the verdict sheet.
Won't be on the verdict. Well, the lower court found that they're not going to be on the verdict sheet, but it's not only prejudicial to my client, it's also prejudicial to Jerome, who will not be in the lawsuit. They could still sue Jerome. So if there's evidence of negligence on the part of Jerome that comes out during the trial, Jerome won't even be in the trial to mount a defense. So it's not.
Well, it's not going to matter because Jerome's not a party to that action. There's not going to be a judgment against them. So that's has no meaning in terms of resolution of the case. But as I understand your position is, I need Jerome on that verdict sheet so I don't get hit for the negligence of Jerome. But he says that, according to what the CPLR says, that you're not entitled to have that party having an allocation of negligence.
If AIC sues Jerome, they have a written indemnity agreement.
You can't force AIC to sue Jerome. Jerome can decide AIC can decide to sue whoever it wishes to sue.
I would respectfully submit that the statute actually provides for the court, if they deem a party to be a necessary party, can summon them. And there is practice commentary in Siegel's about basically forcing a plaintiff to sue a party. And that's alternatively, if the action is not going to proceed for some reason, if that party can't be joined, then the analysis is undertaken of whether the action should still proceed without that
But the fact
necessary
remains,
party.
you can still blame Jerome. I mean, there's nothing that precludes you from blaming Jerome. It's just that the jury, that there will not be a specific allocation of negligence, et cetera, on the verdict sheet. But you can certainly blame Jerome.
Yeah.
The jury will be restricted in their choices of who to apportion fault.
Well,
Yeah, but
your answer to that is that only gets you to the point if you can convince the jury to find Jerome 100% negligent, that lets you off. If you don't succeed at that, that means the jury's going to find you negligent and there's no allocation of fault between the two, so the whole judgment is left to be your business.
If there's any negligence on the part of Jerome, that's negligence that should not be apportioned to Beach. And that would preclude AIC from prevailing on common law indemnification.
But if you prevail before the jury showing that it's all Jerome, then it would be zero as to you.
Yes.
And
You
it
seem very convincing. You may convince the jury.
right.
And then the jury will say it's Jerome's fault and you're free.
And then you're free. It's just that they won't write on the jury on the verdict sheet. They won't put anything. Jerome won't be there, but they'll put zero next to you.
In pursuing the contractual claims against my client, for some reason, AIC decided not to sue the plaintiff's employer with whom they had a contract with a written indemnity provision with insurance. And they are seeking to put the blame squarely on my client and excluding all of the evidence of Jerome's negligence and precluding the jury from apportioning fault to them.
That's another argument you can make before the jury.
We're not allowed to talk about insurance.
No, but you can certainly talk about the fact that they're not suing the employer, right?
That's a fact.
So look at all the arguments we have, assisted you.
So the way you presented it certainly seems like it's something which isn't fair, but that doesn't get us to the point, or does it, that saying that Jerome is a necessary party?
Right.
Complete relief cannot be accorded between AIC and Beach because Beach doesn't get to apportion any fault to Jerome. And
But if
Jerome
Beach
doesn't
is
get to
found
defend itself.
negligent, if Beach is found negligent, AIC is entitled to judgment against them for the whole loss, right?
For the whole or partial,
If
to the extent of
if Beach
Beach's
is found,
negligence.
so as between the two of them, you can reach a resolution. It's just your answer is, why are you coming to us? You should also get Jerome.
They should, according to the statute and
And
Practice
your
comes-
problem is that the statute doesn't allow you to go after Jerome.
The statute bars me from asserting claims against Jerome. So AIC is the gatekeeper to bringing Jerome into this lawsuit, which they've decided not to do.
Thank you. Thank you both. Katacumbas versus Katacumbas. I doubt that's how you pronounce it. Yes, you may proceed.
Your Honor, Chad Flansburgh representing the petitioners, plaintiffs in this lawsuit. To better understand the framework of 3B, I think it's helpful for the court to first understand the family relationships that are between the members of the LLC. Historically, there were two partners of the LLC. Those were Demetrios Katacumbas and his brother, Ilias, who is the silent member of that LLC. The LLC owns a commercial building in the Bronx, and the brothers owned and operated that LLC equally, and they managed it.
So let me, we all know the facts of the case, right? Let me start with a question. Is it your position that the parties, after 8 years, the parties don't have to agree to sell the building, correct?
Yes, that is the
Right.
that is the fundamental issue in this appeal.
And there's nothing in that 3B that says that the parties have to agree.
What
it says is-
explicitly the issue, Your Honor.
After 8 years, one party says to the other, I want to sell, either you buy me out, and if you don't want to buy me out, we sell to a third party.
Yes.
Straightforward. Not even controversial, that provision, correct?
Not controversial at all, and in fact, the family relationship informs that. And if you look at, again, the brothers were equal partners at one time.
We're just looking at the language of the agreement.
Yes.
That's it.
That's
right?
it.
So the alleged ambiguity between 50% and 66%, right?
Yeah, let's talk about that.
So what about that?
Are you talking about the 3B provision?
Yes,
The
3B,
provision?
66% versus 50%.
Well, Your Honor,
What is
I
required?
submit that there is no ambiguity in that. And in fact, you look at the trial decisions footnote 1, he didn't find there was any ambiguity.
Yeah, but I'm looking at it, and it says that 50% a majority interest shall be required to transact any and all business, except to lease a vacant store to a tenant selling food. So what you are seeking to have a declaration is that you are entitled to have 66% ratify or agree to lease modifications. Nothing in this says anything about lease modification.
Yes, and in
We
fact,
agree?
if you go to the
We agree that nothing says lease modification, nothing says lease extension. Tell me what else.
in 3A, it says all checks, notes, and then it goes on to the sentence after that. It goes on to say, no lease can be signed unless all parties have been notified in advance and consent is given by 66% of the vote by the members.
So that's a lease being signed. That's not a modification. That's not an extension, correct? Those words are not there.
Well, I would disagree, Your Honor.
Where is the word modification or extension there?
I think implicitly in signing.
So implicit absolutely means it's not there, right?
Well, Your Honor, no, I would say that it is there. That's a construction.
Okay, then again, read to me where it says extension or modification. It says you can't sign a new lease without 66%. Agreed. I agree with you. Where does it say that you need 66% to modify an existing lease or to extend or to, during COVID, give someone a break? Where does it say anything about that?
Well, again, respectfully, Your Honor, inherently in a lease, to modify that, that means executing a new lease. So I would say.
Really? When I'm signing a new lease, I'm modifying my old lease?
Yes, to change an old lease. And in this case.
Is that what modification means?
Modification is a change of an existing agreement. So if they're changing terms, that's an amendment or a modification. So yes.
But that's not the same as signing a new lease, right? Or signing a lease. Not the same.
Well, you're saying, actually, he's stating that signing a new lease is a modification of the old lease?
No, if you have an existing lease that governs the parties' relationship, that lease, to modify those terms, you must enter into a modification or an amendment of that. And ultimately, Your Honor, what we're saying is that 66% execution language in 3A covers that situation. That's what the trial court below found, and the...
No, because the trial court below used parole evidence, not the terms of the lease itself, correct?
Well,
the trial court didn't say this is clear from the lease. What the trial court said was, on reply, you put in, look at all these texts where the plaintiff asked me for my permit, for the defendants, right? And that's what the court said showed that there was the party's course of conduct, not the lease terms itself.
Certainly, the court did also look at the party's course of conduct. Yes, it did. But again, in footnote 1 of the decision, the court said that the terms of the lease were unambiguous.
Okay, so let's assume we disagree.
Okay.
That the terms are unambiguous in terms of extension or modification. Then what?
Then the court can take in parole evidence, and in this case, like all courts are allowed to do, they can decide intention based on written documentation. In this case, on summary judgment, there was nothing contradicting that parole evidence.
When did you put in your parole evidence? Did you put it in your moving papers?
We did on our moving papers put in what the intentions were.
When did you put in all the texts and all of that information?
That was in opposition, Your Honor.
Or reply to the cross motion, right? And in reply to the cross motion. So that wasn't part of your initial argument is that the lease is clear.
Well, our initial motion was for declaratory and specific forms release on Section 3B. The non-moving party cross-moved, and then in that, we introduced the parole evidence. Now, again, we submit that that 3A is unambiguous, but the court can consider that, and ultimately the court interpreted the party's intentions, which it's allowed to do on a motion for summary judgment, and decided that issue.
Thank you. You have time on rebuttal.
Good afternoon. May it please the court. Constantine Pascalidis on behalf of Christina Katacumbas and Epiros LLC. I apologize for the tough Greek names. Mine is not particularly helpful to that. But with that, judges, if there are any questions.
I want to ask you, what is your course of conduct? Assuming that the lease doesn't specifically talk about modification or extension, and counsel for the move-ins has put in parole evidence showing that the party's course of conduct shows that everyone believed that 66% was required for extension or modification. What evidence do you put in opposition to that?
Judge, if we actually look at the course of conduct, they say requires 66% in the past. It's really only the managing member who has 51% going to the others, informing them what's happening, giving them the right to vote, not binding the vote based on how it comes out. So she's complying with the LLC law, and we're holding her accountable as if she's done something wrong. In every other case with a membership dispute or a shareholder dispute, they're hiding everything. They're not including
I'm asking you, is there a situation where she amended or modified a lease without a 66% vote?
Absolutely, Your Honor.
Well, why didn't you put that in? What did you put in about? Did she say that in her affidavit?
She said that she was pressured into complying with the wishes of the minority party because her nephew said she was an attorney. She didn't think it was correct. She sought legal help, and her attorney read 3A and said, okay, let me read 3B. 66% for a lease to be signed, that doesn't tell me much. Let's read it in conjunction with this very narrow exception that's very specific and says 66% is required only when you have a vacant store selling food. And why was that? She said her other nephew was running the diner on the premises. It was a non-compete. They acknowledge that. It doesn't make sense to read one thing without the other because it's so narrowly tailored.
But I guess what I'm asking is, what you're saying is the evidence that the move put in isn't, can be explained another way.
That's correct.
Okay. So, and that's an issue of fact for a trier to figure out whether or not that evidence, that parole evidence, means what you think it means or what the other side means.
Absolutely, Your Honor. And our position was that there was no ambiguity because we read 3B with 3A. But as soon as Judge Gomez said there's ambiguity in this contract, on a Rule 3212, it was full stop. There was no decision to be made. We have to go to trial. We have to present our case, and then the fact finder can come forward.
May I ask you to address the sale provision?
The sale provision is interesting. I think the record speaks to it very clearly. The idea is if neither party can decide who's selling and who's buying, and they tried to trigger that unilaterally because they understood it was conjunctive. And so they disingenuously offer to buy and sell, knowing that their aunt would never sell.
But even there's something that says then a third party, you'll get an appraisal, right?
Right, and then it forces the sale.
Yeah.
And so the forced sale.
It's your position that you need everyone to agree, right?
Yes, Judge. It cannot be unilaterally
But that
triggered.
3B is so clear that you don't need everyone to agree. I mean, after the expiration of the 8-year period, if either the majority party or minority party wishes to sell its interest in the LLC, this clearly contemplates the idea that not everyone's going to agree.
Yes, Judge, but then it goes on to say, and neither party can agree as to who would be the buyer and who would be the seller. That was never an
So
issue.
there's a process set up. But to buy or sell, you don't need both parties agreeing. One party can force the other one.
No, we don't read it that way, Judge. That would violate the rule against perpetuities. I appreciate that that was brought up because I haven't dealt with that since the bar exam. But to force someone to give away property with an option being held by another person is what is in Symphony Space versus Pergola props that the Court of Appeals said that's an option. That's not a preemptive right. That is an option. You are taking the inalienable right of property from someone without their permission.
How could you possibly be doing that when you give them the option to buy it, or everyone agrees that a third party will appraise and you'll sell it to the third party? That has nothing to do with giving property away without paying for it.
Well, the interest is not being offered for sale. The interest of
They
the
did offer it to you. They did.
They offered theirs. We never offered ours.
I just want to go back to one thing that was brought up. I just forgot what it was.
No, I'm sorry. I'm just.
Oh, you're just thinking.
I'm just letting.
Thank you.
Thank you.
Just briefly, Your Honor, I would
When
like to
you take the
highlight.
position that it's unambiguous that you need 66% on the lease, I mean, how do you deal with the fact that there's clearly in these provisions not the idea of a unequivocal 66% requirement when it talks about a lease a vacant store to a tenant selling food without written consent of 66%? That's not consistent with the idea that every lease transaction needs to have 66%.
Well, I think the easiest way to look at that, those are two different sections. So that's an entirely separate.
I mean, one section says you need 66% and one section says you don't.
Yes, but the other section that says that you don't is in the context of the competing business. And again, if we apply standard contract interpretation of the specific over the general, Your Honor, we believe that certainly 3A is consistent so that
It's true, of course, that it's dealing with the concept of competing business, but it doesn't say that. And why would you need to do that if you've already in 3A said that you need to have 66%?
because it's dealing with a different subject.
But you've already established you need 66%. So why do you need to discuss where you're selling to a competing business? Whether it's a competing business or not, you need 66%.
Well, I think, one, because we were dealing with family dynamics, and the family wanted to be specific about a family business that was operating there. But I want to highlight one important procedural fact of this case, because it is on a summary judgment motion, is that the parties recognized that the issues before the court were legal ones. And we agreed that we would forego discovery and we would brief summary judgment. This work plan is at record page 240. And the idea that somehow that there's issues of fact out there is...
Well, that was my question. So is there anything in the record that challenges your course of conduct argument? Is there anything in the record that says, well, there was a reason that she felt pressured, et cetera?
There isn't, Your Honor. And in fact, the parties agreed that there wouldn't be any need for any discovery on these issues. And we provided the course of conduct. That course of conduct was unrebutted.
But the court is not bound. Is the court bound by that agreement?
The court is not bound by that agreement, Your Honor.
And couldn't that course of conduct, I mean, that's exactly, she said, look, I was nice. These are my nephews and nieces. I asked them. But that doesn't, what the course of conduct evidence doesn't show as a matter of law that I was required to do that. Her testimony was, I went to a lawyer who told me and read the document, who said, absolutely not, you're required. These are my nieces and nephews. I called them up and said, here's what I'd like to do, right? So her argument is that course of conduct information that you put in after your moving papers were submitted doesn't resolve the issue as a matter of law.
Well, I respectfully, Your Honor, I know I'm out of time, so let me just address this. Respectfully, I do not believe that's the standard. In this case, the court is able to consider parole evidence. On a summary judgment motion, if a person does not rebut that parole evidence, the court can consider the parole evidence and determine the party's intentions based on that documentary evidence.
Well, how about her affidavit where she says, I went to a lawyer and they told me this wasn't what I needed to do? Doesn't that raise an issue of fact?
I submit that does not create an issue of fact.
Thank you. Thank you both.
Thank you, Your Honor.
Very briefly, I just want to address this 3B for sale, in that the party's conduct, if this is to be determined that it's fair, the way it's written, they come up with an offer to buy and sell simultaneously, $10 million, $11 million on the other side. They tell us they have some sort of valuation, but we have to agree immediately or else we can't see it. We also have to promise them we're not going to get our own valuation. If that's a fair trigger of this clause, then this clause itself, the way it's being interpreted or the way it would be interpreted to allow it, cannot be conscionable. Again, because they are creating unilaterally the provision to force a sale. They know matter 1545 Ocean Avenue. They know what the standard is for an LLC dissolution, and here's a way we can wiggle around it. And if we don't do that, what we're going to do is we're going to get the court to say it's 66% for everything. Tenants aren't going to vacate. We're not going to let anyone else come into this place. And then we're going to come in and say, you know what, it's financially unfeasible for this LLC to continue operation because of what we did. And so they're going to create the conditions to satisfy their goal of destroying this entity.
No,
Thank you, I yield.
because
I mean, you know, when you bring up the valuation issue, whether in the context of the agreement or not, there's nothing which prevents you from getting the property appraised. And besides that, you're an owner of the property, you have some idea of what it's worth, or you're in a position to figure out what it's worth. So if their offer sounds good, you can take it, and if it doesn't, you can let them buy you out. I don't see that there's anything unconscionable about that.
No, Judge, we had it appraised, and their offer was more than double what the total value of the building was. So it was obvious that this was
Well, then let them buy you out.
But it's not something.
A good deal for you, isn't it?
There is some history, and this is the only thing connecting Christina Katacumbas to her husband. She did not think she wanted it originally. This is all she has, and that's why they want to take it from her. Not because they need the money,
This is a commercial building, right?
It is, Judge, and she operates the bingo hall on that space.
Thank you.
Thank you.
I have People v. Kendall Watts as being submitted. Next case is Mahia versus 770 Broadway owner. Yes, we have enough chairs. You can sit in the first row, whoever's not up. That's good.
Good afternoon, Your Honors. Travis Wong for the plaintiff appellant respondent. It's respectfully submitted that...
If you can move the mic up a little bit, please.
Of course.
Thank you.
It is respectfully submitted that plaintiff has established entitlement to summary judgment under Labor Law 240, subsection 1 in this case, as defendants failed to secure a 16-foot scaffolding pipe that fell and struck plaintiff while he was performing his work. Defendants argue that the pipe did not need to be secured
So
because...
you're appealing only as to M&M, right?
No, plaintiff's appealing the court's decision as to Labor Law 240, subsection 1, to all defendants.
Okay.
And the court actually dismissed plaintiff's 240, subsection 1.
Yeah, but 240, so actually what you're saying is you want it against Broadway owner and Lotz, right? The
Yes,
general
that is
just
correct.
not all
Apologies.
defendants, right?
Apologies.
Okay.
Yeah, thank you
Okay.
for clarifying that. So defendants argue that the pipe did not need to be secured because it was on the same level. The precedent in front of this, before this court demonstrates otherwise. In Douglas v. Tishman, Diaz v. HHC.
So you as plaintiff, it's your position that you're entitled to summary judgment under 241.
Yes.
And of course, and you say that you're entitled to summary judgment against Broadway owner, against Latosi.
Yes, the
and
owner
who
and
else?
general contractor.
And who else do you seek summary judgment against?
M&M as well, right? Oh, no.
No, not M&M.
No.
We have M&M as a Labor Law 2. We have a 200 claim against them, and they've submitted a cross appeal to have that dismissed.
So besides Broadway owner and Latosi, is there anyone else that you think you're entitled to summary judgment against?
There's no one else that we believe that we are entitled to summary judgment against. However, if plaintiff's appeal is granted, we ask that the court also reverse the court's grant of R&B and M&M's motion for summary judgment, as they have not demonstrated that they are not proper labor law defendants. But we are not seeking summary judgment against them.
If you get summary judgment against, if you were to get summary judgment against Broadway and Latosi, why do you care about M&M?
Because they may be a liable party. It's yeah,
Under what theory?
Right, that's
I
what I
think
was trying to
it's-
figure out in terms of M&M, and also
so
R&B.
And R&B.
There's a
And
little
what
bit of-
evidence is there that M&M was at the site at the time?
Yes,
Or
there's a-
R&B.
The facts are a little complicated when it gets to R&B and M&M, as because there are conflicting facts as to who.
Well, what facts in the record is there that M&M was at the site?
There is deposition testimony that they were in charge. There's a contract submitted in the record. I do not have the page in
Is
front of
that
me.
that general contract?
Yes,
That's
that they-
supposed to be triggered by invoices?
That is correct. Yeah.
And was there any, did you submit any invoices that would say that they were at the project at the day, on the date of the accident?
We did not submit that with.
So other than just that general contract, that's it?
Yes.
That's the master contract between Rock and M&M?
Yes.
Okay, and so now, what about Rock?
RB, what
RB,
evidence?
excuse me.
What evidence is it that they were there?
So RB also had a contract to build the scaffold. However, it was unclear who it was, M&M or RB. That's why there's a question of fact and why we're not moving against
Did
those.
RB do more than supply labor?
I thought RB was turned away because they weren't a union shop.
So that's what they're claiming. However, there's M&M's claim.
So what evidence do you have that RB was on the scene at the time of the accident?
Beyond the facts that they were hired to perform this work, we don't. That's it. They denied that they were on the scene, and that's the same with M&M, as they're both denying that they were the ones who were performing the work.
Are there, did you produce any invoices that showed that either of them? Because that was your client's, I mean, the contractor's practice, right?
Yes.
So are there any evidence that either one of them has an invoice for any of the day of, the day before, the day after the accident?
That was not, no invoices were
So
submitted.
other than those general contracts, that's it?
Yes.
Okay.
And I mean, the main focus of plaintiff's appeal is the 240 claim against Lotzi. and the 770 Broadway owner.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is Andrew Showers from McMahon, Martini, and Gallagher. For the defendant, respondent, appellant, New M&M Group, Inc.
You're M&M?
Yes.
Okay. So is there anything that...
You rap?
Look like him.
You're not purple, you're not... is there anything that, in the record to show that M&M was on the... was at the site?
No, Your Honor.
We have no invoices, we have no testimony, nothing that M&M was there, is that correct?
Correct. I think there was a comment by our client that they were called after this accident to come and clean up. That was afterwards. Prior to, they had no involvement with this job site, no, excuse me, my voice is going. Yeah, something like that. No invoices, no.
Do you have a contract with anyone? Did you have
Not
a
for this
contract with
project, Your Honor.
Did you have a general contract with Rock Group, or that was only R&B?
Their Rock Group is claiming that we have a contract with them. My client testified that that contract is a fake. It's not his signature. He does not have a
But
contract.
anyhow, even if it wasn't fake, you came on the scene, if you came on at all, after this occurred.
Yes, Your Honor.
Therefore, you have no liability.
Correct, Your Honor. No liability at all.
And it's your position that there's no evidence placing you at the scene before the accident.
Correct, Your Honor.
Thank you.
Thank you.
You represent...
I represent the Rock Group, which is the third-party defendant respondent. And I think I would like to begin with the fact that it's not true that there's no evidence that M&M was at this site. There's testimony from plaintiff who says he was working under a foreman, Jose Diaz, and that he learned that Jose Diaz was working for an independent contractor named Manola. Then Minash, who is the owner of M&M, said that he had an employee named Manola working for them in September 2016, which was the time of the accident. And he also said that he had employed a number of individuals named Jose Diaz in the past, and it was possible that he employed someone.
Are there any documents which establish this?
There is, so we have a subcontract with M&M, and while it's true...
Is that the subcontract that it doesn't have blank spaces filled out?
The master one?
No, there's a subcontract agreement between the Rock Group and M&M, and that has...
Isn't that referred to as the master contract? A master contract between Rock Group and oh, that's the one with R&B, and then there's one between Rock Group and M&M, right?
Yes.
That's dated June 24, 2016.
I believe so. But that does bear the signature of Mr. Minash, and although he says in his deposition he denies that was his signature, there's other evidence of the fact they were bound by this agreement, including the fact of the signature itself, other evidence placing M&M employees at the site.
What other evidence?
Well, the testimony they had previously referred to about...
There are a lot of Jose Diaz's, and this one could have been one of the Jose Diaz's that there are a lot of?
And that there was an individual named Manola there as well, who Minash did say was an M&M employee at that time.
So you moved for summary judgment, right?
So right now, we're respondent to M&M's appeal because they're not liable to the plaintiff because it's been established, has it not, that that the plaintiff was your employee, so there's a workman's comp bar.
Excuse me, can you repeat that last part?
You have no liability to the plaintiff because he was employed by you according to workman's comp.
Yes.
And that's not challenged. As between you and plaintiff can't go after you.
No, he cannot. We do think, though, that because this isn't a 240 subsection 1 case, that means that there should be no claims against the general contractor who is the third-party plaintiff. So we think that because this shouldn't be a 240 case, that moots the third-party action against us. So that's...
my question was, did you bring in, are there any affidavits from whomever Jose Diaz was or Manolo that they, in fact, were employed by or had a relationship with M&M?
No, the evidence that we're relying on is the testimony from plaintiff, from Mr. Minash, and then there's also testimony from the representative from RB that he says that the Rock Group would not send workers to the site. It contracted out its work. the inference being that M&M, who was the signatory to the agreement, would be the one with individuals
That's the
there.
inference that you would draw?
Sorry?
That's the inference that you would draw because R&B would not go to the site, that meant that M&M would?
Sorry, not that RB would go to the site, that Rock Group wasn't there.
That Rock Group wasn't there, then you draw, from that, you draw an inference that M&M was there.
I think it's a potential inference. It's one piece of evidence that would create issue of fact about that. So overall, we think this isn't a 240 case. I think plaintiff would have you believe that just because an object tips over at the same level of as the plaintiff, that makes out a 240 case, and that's just not borne out by the case law. There's additional criteria that has to be met.
16-foot, he was struck by a 16-foot scaffold pipe that had been left unsecured at its end.
Right, but there's no evidence that was expected or required to be secured for the purpose of the work being performed, which is what they need to do. Additionally, I think the record reflects when you take
Why did it fall?
Well, plaintiff's testimony, he doesn't have personal knowledge. His belief is that it fell because someone told him that someone else kicked it over. But I think that in addition to whether it was required or expected to be secured, there's also a question of whether it would have been contrary to the work being performed to secure the pole. And the work that was taking place at the time of plaintiff's accident was they were taking these poles and incorporating them into the existing structure. And I think that it would be illogical, given that they were installing this pole.
It would be illogical for that to not have a person there holding that pole so it doesn't fall on anybody?
I think that the testimony is that it was imminently to be installed in this, and plaintiff testified that he had never seen the pole being secured previously. And I also think that, if it comes down to someone holding the pole or it laying on the ground, then this accident taking place isn't because of the absence or inadequacy of a safety device of the kind enumerated in the statute. It's because of how it was, someone wasn't holding it or wasn't on the ground. And so I think that makes this only a general hazard of a construction site and not the kind of extraordinary hazard that 240 is designed to protect against.
Thank you.
Thank you.
Good afternoon, Scott Kornbaum for RB New York Enterprises, Inc. Plaintiff and M&M admitted three things that are relevant. First, plaintiff's work was directed and controlled by Prajit Singh, AKA Rocky Singh, and Jose Diaz, who he understood to be the boss and foreman of Rock Group New York, respectively. Two, as Mr. Mahia continued to hold the ladder, a cross-brace pipe, which had been unloaded from the truck and placed against the building by a Rock employee wearing a Rock Company t-shirt, struck Mr. Mahia on his helmet and subsequently the top of his right shoulder. Three, this is the only persons to provide any direction or supervision to Mr. Mahia was Rocky and Jose Diaz. With those admissions, just first with the 240 claim, we were nothing more than just a subcontractor that supplied workers to the job site. So there is no reason to keep a 240 claim, and I defer to my co-counsel regarding whether there should be any 240 liability at all as against RB. And then as we note in our brief, plaintiff's argument for M&M and RB New York liability under 240 consists of the following sentence. Additionally, insofar as liability pursuant to Labor Law Section 241 is found to be applicable to the facts of this case, defendants M&M's and RB New York's motions for summary judgment on the issue of Section 241 should be denied as they have not established that they are not labor law defendants under the law. That's wrong. I mean, there's so many reasons for this court to reject any 240 liability against RB New York. Now, M&M has appealed against RB, has brought an appeal because the trial court dismissed its common law claim for contribution. There's no evidence of negligence on the part of RB in this record. I hope you're nodding your head, Judge, because you agree with me. The only liability could be if some RB New York employee was the one who actually kicked the pipe, because there's no evidence anywhere, not the pipe, but the cross brace, and there's no evidence. They've challenged it on hearsay, but Mr. Mahia testified that an employee wearing a rock group T-shirt told him that he accidentally kicked the pipe. There is no evidence from anybody that says, I saw an RB New York NY employee there. And I don't know if there's no light because my time is up, but there's just no evidence anywhere in which for a jury to find that RB New York Enterprises was negligent. Finally, Lotzi doesn't file an appeal, but seeks to bring RB New York back in, and it makes some serious misrepresentations. Like, shockingly, it says that the trial court never dismissed the claims of negligence, overlooked the fact that there were disputed facts of negligence. Well, you judges, you can see the opinion itself. It's just shocking, that representation, at page 40 of the record. However, with the finding that defendant Lotzi, Broadway, Quest, and RB New York were not negligent, the common law contribution and indemnification claims against these parties fail.
Thank you.
All right, thank you, Judge.
Good afternoon, Your Honors. May it please the court. I'm Sean Hutchinson from Gallo Vitucci Clark for Lotzi. Our position in this case is that we were the general contractor. We did not have any employees on site. All the work was performed by subcontractors. So the court properly dismissed the Labor Law 200 and common law negligence claims against us. And in fact, plaintiff hasn't even appealed that portion of the determination. Concerning Labor Law 240, my co-counsel here have said what needs to be said on that point. This pipe, the 16-foot pipe, while it was 16 feet tall, plaintiff also said that it was light enough for him to hold in one hand, which makes a pipe, as you would imagine, particularly light. We also don't know specifically, or there is no evidence to demonstrate where the pipe was specifically oriented next to the plaintiff, how far away it was, or what it was that specifically caused the pipe to fall. We think
Isn't it enough for the plaintiffs to state that the pipe did in fact fall? 16-foot scaffold pipe, it was unsecured and it fell?
Well, I think the question, Your Honor, is whether the pipe required securing for the undertaking.
I'm sorry?
I think the question is whether or not the pipe required securing for the undertaking.
Is it your position that a 16-foot pipe that is leaned against something for a while until they decide it's time to be used for the scaffolding should not be secured? Is that what you're saying?
Well, in addition to testifying that he could hold a pipe in one hand,
No, I mean,
he also said that he had never seen a pipe secured when it was.
okay, but that doesn't answer the question as to whether or not it's your statement that a 16-foot pipe that's leaned against a building that is going to eventually get put up as scaffolding shouldn't be secured while it's leaned against the building.
We have a difference in opinion on that, Your Honor.
I guess so.
Regardless, plaintiff is not entitled to summary judgment on Labor Law 240. There's no question about that. And concerning our contractual indemnity claims, the court properly found questions of fact regarding the contractual indemnity claims against Rock Group and against M&M. The court should have also found, the court should not have dismissed our Lotzi's contractual indemnification claim against RB because RB could have been the plaintiff's employer.
Could have been.
Could have been the plaintiff's employer.
Okay, but that was found against you in the workers' comp, right?
Yeah.
So the workers' comp found that
And
that Rock Group was
The employer.
the employer, but that my understanding is that determination didn't necessarily apply to whether or not RB could have been the employer instead.
I'm sorry, repeat that?
Yeah, what?
So they made a determination that RB was the plaintiff's employer, but that doesn't mean that RB was in fact the plaintiff's employer. Rock Group, excuse me. Is that what you're saying?
Correct.
Okay. Let me just ask you, other than what M&M argued about, or the the information that was given about the M&M being on the site, do you have anything else other than someone saying that there were some Jose Zias's and one of them might have been on the site that day, and that the plaintiff knew some other guy and he was there? Anything that you want to add to that?
I think,
M&M?
I think, Your Honor, the fact that plaintiff was supervised, directed, and controlled by Mr. Diaz, and there's a question about whether or
I
not.
thought he said he was supervised by Mr. Singh.
Yeah.
I believe Mr. Diaz was his foreman at the project site.
Right. And is there any information that Mr. Diaz is an M&M employee?
The witness testified that Mr. Diaz, he couldn't rule out the fact that Mr. Diaz could have been an employee of his company.
And that's, you think, enough to raise an issue of fact?
We believe so.
Okay.
It's your position that Lotzi is not bound by Workman's Comp's holding that plaintiff is an employee of Rock Group, because you weren't party to that.
Correct.
Thank you.
Thank you.
Your Honors, I will be very brief. I just want to address two things that were said, or three things. Plaintiff never testified that he could pick up this 16-foot pipe with one hand. He was testified about an 8-foot pipe that he had removed from a truck earlier that day. He had never removed these 16-foot pipes, so that's incorrect. As well as defendant's contention that the pipe was, it would have been contrary to the work to secure the pipe at the time of the accident. That doesn't make any sense. It was being stored. It wasn't actively being installed, and even if it was actively being installed, there is a plethora of case law about objects that are actively being installed that are not adequately secure, that fall, and plaintiff is entitled to summary judgment. If there are no further questions, I will rest on my brief.
Thank you.
Thank you.
I also will rest on my brief unless there are further questions for me. Thank you.
Thank you. Rodriguez v. Riverside Center.
May it please the court, John Shore for plaintiff appellant. Since my brief was drafted, Your Honors, I know this court is very aware of a recent case since three of the justices today, Justice Friedman, Justice Weber, and Justice O'Neill Levy, were on the panel of that case, and it happens to be the same name, Rodriguez v. Riverside Center, Site 5 Owner LLC, 23183rd 603, that came out in October of 2024. I mean, it's the same site, same last name, no relation to my client, but it follows the Court of Appeals in Prats, follows Sakurai. In that case, the plaintiff was...
So your client was delivering tiles for the installation at the site, is that correct?
Correct.
But he had nothing, he was only the delivery person, right? He only drove the truck or whatever with the tiles on the truck, and he is bringing it into the to the loading dock at 4:30 in the morning or whatever, right?
Correct.
But he has nothing to do with the installation of the tiles or the work, the construction work that's going to be conducted with those tiles. Is that correct?
The work, he did not specifically install the tiles.
He's only delivering the tiles.
He was delivering the tiles, which was, he worked for the tiling subcontractor, Port Morris. It was in furtherance of the work.
It's in furtherance of the work because without the tiles, they could not do the work?
Exactly.
But he had actually nothing to do with the actual installation of the tiles.
Similarly, in the Rodriguez case that Your Honor was on the panel of the 23183rd 603 at the same site, Mr. Rodriguez, a different Rodriguez, had nothing to do with the installation of the actual work. He was a delivery person. He was delivering the cement. And
well, the cement was going to be used for the construction at the site, and it was the chute, I guess, that the cement was coming out of that he had to clean in order for in order for future deliverance of the cement, right?
the cement was being delivered. He was a delivery person. In fact, Your Honor, Mr. Rodriguez in that case did not even work for the super subcontractor that was the cement contractor. He worked for the subcontractor, Jenner, which was just a supplier. He had nothing to do with the installation, but that case, along with the Protz case, makes it very clear that there's no isolation of the activity itself. Whether or not the work was being done that was not a protected activity at the time is irrelevant under Protz because it was ancillary and in furtherance of the overriding contract work. In fact, my client in this case has a stronger basis technically than Mr. Rodriguez in the other case because he actually worked for the tiling subcontractor. He made multiple deliveries throughout the course of this project, and unequivocally, under the Court of Appeals standards in Protz, it was part of the work. It was in furtherance of the work.
So wouldn't any delivery and unloading of material at a construction site, under your theory, under your argument, wouldn't that always constitute a necessary step, I guess, in the construction, in the protected activity?
First of all, if it was in connection with the actual construction work itself, if it was just some isolated delivery, it would not. Here, my client was an employee of the tiling subcontractor, which was hired by the general contractor.
What if he hadn't been? What if he was just delivering tiles on a one-shot basis and he wasn't an employee of a subcontract on the project? Would he get the protection of 241?
Much more limited set of facts than in my case, where my client, and I certainly answer your
but what
question.
about it under the facts of my case?
If it was a one-shot deal and it was in furtherance, if that was in furtherance of the installation of the construction work, in that case, we're talking about a 46-story building, yes. But in my case, my client...
But again, so if it's a one-shot delivery of tiles to the building, would that give rise to 241 liability?
Under those circumstances, they would, under the Protz case and the case law, because it was in furtherance of an enumerated activity. In my case, though, there's far more grounds to warrant summary judgment in my client's favor. It was clearly a protected activity. He was doing this for several months, and he worked for the actual tiling subcontractor that was hired by the general
But not at this
contractor.
project. Not at this project, right?
What's that?
Not at this project. He worked for the tiling subcontractor, but he wasn't stationed at the project.
He It doesn't matter. He was working, it was part of his work.
I
He
didn't,
had
I
to
didn't
go.
say it did. I'm just trying to have the facts straight.
But for instance, in the other Rodriguez case, there was even less grounds because the truck driver who worked for the supplier, not the actual subcontractor that was doing the installation.
But that was also not a one-shot deal, isn't that so?
Correct. That was not a one-shot deal. Like in my case, this was going on. My client sometimes would make 2 deliveries a day. He was on that site for a couple of months. He made 20 to 30 of these deliveries. And in the other Rodriguez case, the delivery truck driver, again, who was not an employee, he was the employee of a supplier, not a subcontractor like my client. He went up on his truck and he fell off the platform of the truck.
Right, but there were a lot of other issues
Right,
in that particular case, but you have time on rebuttal.
Okay, thank you.
Good afternoon. Paul Howansky with Harrington, Acco, and Monk for the respondents Tishman and Riverside. Our position is pretty straightforward. Plaintiff is not amongst the special class of workers entitled to the protection of labor law. He's a delivery driver. That's the full extent of his work duties. He does no actual construction work.
But he is delivering materials that are going to be used in the construction project, and he also has been doing this for a period of time, right?
Okay, but under labor law, let's start with labor law 240. It's crystal clear. The delivery task that might be tangentially related to the protected work activity doesn't afford you the protection, okay? The Pratt's case, which counsel relies on, the Court of Appeals
Someone
case.
is making deliveries to the project on a daily basis. Would that person be entitled to 241 protection?
No, because he's not ever performing an enumerated protected activity.
So you
He's
have
only
to
delivering.
be actually, so he would actually have to be a tile installer.
In that circumstance, yes, and it's right in the Pratt's opinion. It states that that the plaintiff needs to be a member of the team that undertook an enumerated protected activity. He wasn't.
So let's say the enumerated protective activity is installation of the tiles.
Okay.
You don't think the guy who brings the tile is a member of the team of
He's
people?
not, because
Why not? How are they going to get the tiles there?
A completely different union. The tile installers are completely different, whereas the delivery driver is a teamster. He's not even authorized to do this work, okay? And B, it's in Pratt. It's also in the First Department case of Toro, where the plaintiff tried to make the same argument. Well, in Toro, it was demolition work, okay? And the plaintiff was employed by the same demolition company, same contract, demolition in the contract, clearly a protected activity, right? Well, the court said, well, even though the plaintiff's employer's contract called for protected activities such as demo, plaintiff was not a member of the demo team, just a truck driver.
What about the cement mixer delivery person who's bringing the cement and unloading the cement, which is then used to fill in some floor or some wall or whatever? Would that person fall under the protection? Why wouldn't he be engaged in a protected activity, even though his function is to deliver the cement, but go try to lay the cement floor without his delivery?
I think it's it's apples and oranges to the case that we're having, where it's simply a delivery material. We're not talking about cleaning. We're not talking about concrete chutes. We're not talking about elevation risk hazards.
Well, he's got to put down the tiles on the loading dock, doesn't he? And you can't tile the floor without the tiles.
There's case law that supports that that's just too far removed from the actual construction.
I just want to say, Pratt's also states it is neither pragmatic nor consistent with the spirit of the statute to isolate the moment of injury and ignore the general context of the work. So are you not ignoring the general context of the work, meaning you need the tiles have to be delivered to the site, and so the delivery of the tiles to the site becomes a part of the construction?
Your Honor, respectively, you're putting the cart before the horse. The first thing that's paramount, specifically, especially for 240 purposes, is the plaintiff has to be tasked with some sort of enumerated activity. At some point during the project, he has to do the construction or the pointing or the painting or the all those lists.
Having sat on the previous Rodriguez case, give me the roadmap of how, in the face of my having joined in that decision, I find for you here.
Since I was on that case as well.
Okay.
It's
simple.
And Judge O'Neill Levy as well.
Okay.
So why were we mistaken?
Well, here, okay, it's undisputed.
different?
It's a limited activity truck driving, okay? He never enters the site. This is actually, the accident happens outside the loading dock area, outside the wind flaps. He
does enter the loading dock, doesn't he?
He doesn't get anywhere past the loading dock.
Does that matter?
It does. It does. It does for plaintiff. It didn't come up yet, but
And Riverside, he entered the site with the cement?
I'm sorry?
In Riverside, the previous Riverside case, he entered the site, he's on a truck.
Right, but that Riverside case has so many other facts that don't comport here. I think that
Give me the main one that distinguishes it between that case and this case.
Well, okay, this happened off hours. This happened 6 in the morning before any construction started. Okay, this happened in a roadway. This happened with a teamster who's not authorized to do any type of construction work. This happened.
Have any of our prior cases or any of the cases by any other department or by the Court of Appeals talked about Teamsters, truck drivers versus the individuals who are performing the work? Is there? I don't recall any mention. You're the first person, first attorney who's argued this. I don't recall anything in our prior cases that talk about Teamsters.
Not necessarily Teamsters, but
you're just relegated to one
But the Toro case that I did mention, which is a First Department case from 2011, is a truck driver who was employed by the demolition contractor. So there was there were likely different unions involved there too, because in the Toro case, he was simply a truck driver, and even though the plaintiff was pushing that, well, he was performing the work pursuant to demolition contract, he has to be a protected worker. The court said, no, that's not what counts here. What counts is what his enumerated activity was, a truck driver. He's not performing construction work, and therefore he's not protected under the labor law.
Thank you. You do have time on rebuttal, I believe. No, you don't.
Good afternoon, Your Honors. If I may, or if it pleases the court, my name is Eartha Jean-Baptiste. I'm from Magnan, Martini, and Gallagher, and I represent the defendant respondent, 5 Star Electric Corp, in this matter. I'd first like to start by addressing the former Rodriguez case. I submit to you that it is distinguished from this matter. It's distinguished in that, one, the plaintiff in the former case engaged in 2 tasks. Not only did he deliver the materials to the subject premises, but he provided the means by which that material was used on the construction site, and he participated in the use of the cement on the construction site. I submit to you that the purpose of a cement pump truck is to efficiently and quickly deliver large volumes of concrete to hard-to-reach areas at the construction site. And one of the standards for protections under the labor law is that the plaintiff has to be permitted or suffered to work on the building and on the structure. In the former Rodriguez case, by delivering the cement onto the construction site but using the truck to place it in a manner that it will be used, the plaintiff in that case, he submitted and was permitted to work on the building and in the structure.
So 5 Star was the electrical contractor?
Yes, Judge.
And you were providing electrical installation and temporary lighting, is that correct?
That's correct, yes.
And so did your work in any way deal with the tile work or with maintaining the ramp or the area surrounding the ramp? Did you have anything to do with that?
The temporary lighting that was provided covered the areas where the truck delivered the materials.
The loading dock area?
The loading dock area, there were 3 sets of lights. One was where the truck reversed into the loading dock area. 3 was over the host and ramps, and 2 of the lightings was towards the back area where the general contractor, Tishman's office was located.
Did you have anything to do with the tile work?
No, Judge.
And did you do anything in terms of maintaining the ramp?
No, we did not.
It's your position, is it not, for purposes of the labor law, it's your position, is it not, that for purposes of the labor law, 5 Star is not an agent?
It's not an agent, that's correct, Judge. We do not supervise, direct, or control the plaintiff's
Could you
work.
be liable for common law negligence?
I submit to you.
The claim is that your lighting was inadequate.
I submit to you, Judge, that we could not be liable because there isn't sufficient evidence that the lighting provided to the plaintiff was not sufficient.
Well, the plaintiff testified that it was dark. I mean, it's 6:30. It's between 6 and 6:30 in the morning when he fell. He said that the lighting was inadequate. I recognize there was testimony, I believe, from your witness or another witness stating that the lighting was on and it was fine.
Yes, Judge. The reason why I'm stating that we weren't liable under common negligence is that the plaintiff worked at this site and made deliveries for approximately a year before the subject incident under the same lighting conditions. In addition, there were 3 individuals at the construction
But if the
site.
plaintiff testifies that the lighting wasn't adequate, that wouldn't create an issue of fact?
Judge, I believe that the plaintiff's also contradicting his own testimony because he also testified that the lighting was bright in the area where the truck was reversing into.
I thought he said that he had to be careful because it would always be dark. He says there were no lights outside the building where he backed in. There was some lighting, he said, but it was minimal.
Judge, I submit to you that the area...
And one last thing, he used the lights on his vehicle in order to actually illuminate the area.
Judge, I submit to you that the area where the accident occurred, 5 Star was not responsible for lighting per the contract. It occurred outside the premises. It wasn't in the area where we had the 2, 3, the second set of lighting. It occurred outside the premises. The areas where we were responsible for lighting, the plaintiff testified that it was bright, that he has made multiple deliveries, and there were no prior complaints of improper lighting in that area. There were 3 individuals responsible for monitoring the lighting conditions in the area. There was someone from 5 Star. There was someone from CR Safety Group. There's also an individual from Tishman. They've all testified the lighting was on 24/7. They've all testified that the lighting was adequate. They've all testified that none of these entities received any complaints about the condition of the lighting. The accident occurred when the plaintiff was stepping on the ramp, which was outside the premises, and it was an area that 5 Star was not responsible for lighting per the contract. And even in that case, plaintiff himself never made complaints about having to maneuver before the date of the accident. He also never asserted that the lighting conditions on the date of the accident was any different from the entire year of him making the deliveries at the subject premises. And as such, because of those instances and those facts and the testimony of the plaintiff himself stating that it was bright in the area where we were responsible for lighting, I submit to you that we should not be found liable under common negligence.
Thank you.
Thank you.
I don't want to waste my time on the negligence. I know they did not appeal, and that's not an accurate statement of the record. They set up the lighting as part of the loading dock, and in fact, the loading dock was a temporary structure in furtherance of the construction work, and they were hired to set up the lighting, which was an obvious problem. But the loading dock was part of the construction work, and that area was an unprotected opening that caused my client to fall. And I don't think counsel has an accurate reading of Rodriguez, because he said there's a distinction between the driver in Rodriguez and my client, because my client, the driver in Rodriguez was at the construction site. First of all, the driver in the October 2024 Rodriguez, he delivered the cement. he worked for a supplier that was not participating in an actual enumerated activity like Port Morris, which was my client's employer. In fact, when when the driver in the 2024 October case had his accident, he wasn't even on the construction site, which was their argument. They were at least 10 feet away. They had to drive away to do this washing. My client, in furtherance of the work and made multiple deliveries, he was on this temporary platform, which was in furtherance of the construction work, and he fell as part of his duties, unfortunately. It was in furtherance of the construction work, and it was part of the construction work. And as Justice Weber noted, there is no demarcation in Protz about Teamsters. It was part of the work. He was an employee of the contractor.
Thank you very much.
Okay, thank you.
Vigliano Associates versus Gaines.
Good afternoon, Your Honors. May it please the court. My name is Joshua Krakowski from Davidoff, Hutcher, and Citron, and I'm here representing the plaintiff appellant, Vigliano Associates. The last case of the day, there's a lot of briefing. The briefing in this case is almost as long as the record, but there's one key issue that I want to focus on. We both sides agree that the plaintiff, Vigliano, is a beneficiary of this contract. The issue is he an incidental beneficiary without any rights, or an intended beneficiary who can sue to enforce the payment obligations? That's Section 4K of the agreement between the defendants, defendants, the Magnolia defendants.
Can I ask you a different question? What are you alleging is the breach? Why, first of all, why is there a breach?
Well, sure. The breach is because we have a non-terminable, irrevocable right to the commission payments related to the 5 books.
Did you? There's a number in the contract, right?
Well, it's not. It's a percentage, yes.
Right. And it's 12.5 million, right? And then there's an amendment that reallocates that money to the books that you and everybody agrees you got that. You're entitled to that money, right?
Well, except for the fact that one of the books changed authors, but yes.
Okay, so let's assume everything else is true, right? So you suffer no injury because you're getting the same amount of money, except the one book, right?
Right.
And you can't force someone to write a book they don't want to write, right? Mm-hmm. So you got no injury. So a breach is a breach with damages, right? You have no damages because you're getting paid the allocation for the books that are being written. You're still getting paid the same amount of money. The parties took care of you in that way. And the one book that is not being written anymore can't force somebody to write that anyway, correct?
Well, let me make one addition to your factual scenario, is that we're not getting paid the commissions on the book 5.
Right, but if the person didn't want to write book 5, you couldn't force them to do that. So that couldn't be a breach as to your commission, because if Joanna Gaines says, sorry, too bad, not writing that book, you'd get no commission anyway.
Well, if that were the case, that would be correct. But in this case, Ms. Gaines did not say, I'm not drafting book 5. She did draft book 5. She prepared book 5. The Stories We Tell is a very successful book. She drafted it. We're not getting commissions on it. That was book 5 under the agreement that was signed.
No, that's a different agreement, right? She didn't write the book that was under this agreement.
She did.
Okay, all right. Let me ask you another thing. So why do you think that you have irrevocable agency coupled with an interest in this case?
Well, because the Section 4 case says exactly that. It says that we have an agency coupled with the interest. That's on record.
Well, right, but can we agree that words don't necessarily, you could say what you say. I can call myself purple. That doesn't mean I'm purple, right?
Correct.
So what in the contract shows that you have agency coupled with an interest?
Well, I mean, the language says it, and this is
Okay, I agree, but here we go again.
This is a
But I'm
CPLR.
asking you what shows that.
Well, first, the answer to the question is the contract in 4K specifically says the provisions of this Section 4 shall survive the expiration and/or termination of this agreement. It says that precisely. The rights that we have to the commissions cannot be taken away.
Right.
We are an
And
intended
you're getting the commissions, aren't you?
We're not on Book 5 because there's two payments.
Okay, again, and
Forced to write Book 5.
right.
Well, no, here's I think where the disconnect is that there are advanced fees that were paid on the 5 books, right? And assuming that you're okay with substituting one author for another, let's set that aside for the moment. But the advance payments, okay, fine. We received the advance payments in the amendment, but it's the commissions, it's the royalty payments that follow that we're not getting. We're not getting the royalty payments on the Book 5. They reallocated the advance payments.
And what the Court of Appeal says is if you can't force somebody to write that Book 5, right? That, under that contract, you cannot force her to write Book 5 under that contract.
We can't force anybody to do anything.
No, that's, I mean, there are plenty, you can't claim a breach of contract. Look
No,
at
I-
ABC versus Wolf, right?
Fine, I agree. I cannot force
So
her.
aside from Book 5, you're getting paid everything you're supposed to be getting paid. Do we agree?
Aside from Book 5, and
And
aside
since-
from the
and
fact
since-
that one of the books changed authors.
Right, but you still got paid your money.
No, we haven't gotten paid any commissions on Book 5 at all.
No,
No,
just
not
got
on
the
book
advance
5. You said aside from another book that changed authors.
Right, that's Book 4.
Book 4. So you received everything as to book 4, right?
We contracted to have 5 nonfiction books written by Joanna Gaines.
Right, and you claimed that Chip wrote book 4 or whatever.
Chip, right, that they made the amendment, they said,
Chip wrote it, and therefore it would not garner as much book sales, I guess, right? With Chip writing it as opposed to
Discovery,
Joanna.
Discovery may reveal that, I don't know, but this is a motion to.
But you're not arguing that that's a breach of the contract,
Yes,
are
of
you?
course it is. Of course it is. We contracted for 5 books with a specific author that's identified.
Well, that was the other
You
thing.
didn't contract, you're their agent.
Well,
You contracted that we will get a certain amount of the profits that they make, correct?
Correct.
CMP James.
Correct.
C&J Games.
C&J Games.
Right, they're the author, so it's
No.
Chip,
The
it's
author.
Chip and Joanna,
No,
right?
the author is defined as Joanna. That's page 1.
But I thought you were representing both of them.
Perhaps, but we contracted for the author to be Miss Gaines. That was the author under the contract. That's on page 1, very first provision on R73. It says Joanna Gaines, open parens, quote, author, close parens. She's the author. That's who we asked. That's who we contracted to have. But let me just, before my time is up, there's one point about intended versus incidental beneficiaries. And I want to highlight a case that we cited. Actually, Justice Friedman, you were the author of, the Commissioner of Department of Social Services of the City of New York, 2018. It is generally established that an intended third-party beneficiary status is demonstrated when, quote, a benefit is provided directly to a third party in the agreement.
But you're not getting a benefit. All you're getting is the agreement that the HarperCollins will pay you. That is a completely different, you have no benefit from this agreement except that HarperCollins, HarperCollins agreed to pay you directly. That's all your benefit is. You don't get a benefit from the books or anything else except the agreement by HarperCollins to pay you your percentage between you and your client directly, rather to them and them have it paid to you. That's your argument why you're a direct beneficiary under the contract?
I mean, to say that we're going to get paid 7.5% commissions on a
You're not
best-selling
getting
book is
paid
not a
by
benefit?
HarperCollins. They're paying Chip and Joanna Gaines. All they're saying to you is, rather than sending it to them and then sending it to you, we will pay you directly. That's all that's all you have under the contract.
Well, that's what the trial judge ruled, is that this was just an administrative convenience, but there's no basis for that. This is a payment. We were protected. If you read 4K, and I just ask that the judges read the section, because it really is that simple. Look at this section to determine whether or not we're getting a direct benefit. It says we're getting paid. It says it's irrevocable. It says we're the agent. That should be enough to demonstrate that we have enforceable rights and that you can't just take them away with an amendment, because what would stop HarperCollins and the Magnolia defendants from saying, the day after signing this agreement for 5 books, the next day say, you know what, we're amending it. There's going to be 0 books, and Vigliano gets no money. Under what I think
That's a problem between you and your authors. You are representing the authors. You are not you have nothing to do with the authors versus the book publisher. So you sue your authors and you say, you can't cut me out of my commission by doing that. But you haven't sued the author.
That's exactly what we've done. We're suing the author.
No, but, okay, so sure, but you're seeking judgment against HarperCollins also, correct?
Other who?
Against
Other parties? There's a number of
publisher.
No, we didn't sue the public. We didn't sue
I'm sorry.
HarperCollins. We're only suing the Magnolia defendants.
Oh, I'm sorry. Okay.
Right. So
But I wanted to just get back to the contract, because the contract also says that C&J Gaines, Chip and Joanna, right, C&J Gaines shall be substituted for the term author, except where context reasonably implies the latter, right?
Okay.
So, again, you're talking about a breach of contract because Chip wrote book 4. But it appears that under the contract, that was not a breach because both are named as authors. Chip and Joanna are named as authors. And I know you made the argument that, a book written by Joanna is going to sell more than a book written by Chip. I don't know that that's true, but the contract does say that they're both authors.
Well, I mean, not in the very first provision, which is, what our understanding was. And just, we have sued the author. That's what this is. We're the third party.
Right. Yes. Of the contract between them and their, right?
Correct.
Right.
Yes. Mhm.
And you have a separate contract, right, with Chip and Joanna Gaines?
Not that I'm aware. It's not in the record. No.
How is it that you came to get 12.5% of the?
Well, it's 7.5, and it's because
7.5.
right,
I'm sorry.
It's because we are the literary agent. We
So
negotiated
when
this
you
deal.
you say you just walked up to them one day and said, "I'm without any contractual agreement. I'm your literary agent. I'm getting 7.5."
No, there was a business relationship.
Exactly, and
There
there
were-
are contracts and all of that, correct?
It's not in the record, and so it's not outside the scope of this. But yes, there was a business relationship. We were an agent. There was something in writing that said we're the agent, but I'm not aware of anything that said we're entitled to 7.5% commissions on these 5 books, other than the agreement.
Yes, okay.
Thank you. You have time on rebuttal.
Thank you.
Good afternoon, Your Honors. My name is Zach Kleinsasser. I represent the Magnolia defendants. Just to follow up on Your Honor's question about the contract. Frankly, as a sophisticated publishing agent, it has always shocked us that a claim, if there is a contract, would not have been brought on a contract between Vigliano and the authors. That's not what we have here. What's pled in the complaint, we're not aware of any contract, but it's certainly not pled in the complaint. What we have is a pleading for the publishing agreement, and there is no breach of that contract.
So that is my question to you, are they getting paid everything that they are entitled to get prior to the amendment? Is there any money they are being cut out of because of the amendment?
No, Your Honor. And Vigliano acknowledged that below. Vigliano is being paid the advance commission and royalties on the 4 books that were published pursuant to the agreement.
And we all agree that no one can force the author to write a book that the author doesn't want to write.
That's right. And let's just be clear that the agreement is very clear that there is no obligation to publish 5 books. In multiple places, we cited them throughout the brief. It's contemplated
Like
that fewer than
2 or something like that were to be decided. The content of two of the books was to be decided at a later date or something of that nature.
correct. And more fundamentally,
the agreements in the provision give my clients the right, and HarperCollins the right, to amend the contract as they see fit. If they want to publish 5 books, they can. If they want to publish 0 books, they can. If they want Chip to author a book, that can happen. If they want Joanna, that can happen.
Does, so and the agent has no ability to stop you from amending the contract? under
Agent
this-
has no rights whatsoever. And so a key argument that Vigliano...
That's what then I want to ask you, is this party an intended third-party beneficiary of the contract?
Absolutely not, Your Honor. The case law is crystal clear. There must be an intent by the parties, and the standard is very high. It's got to be a clear intent to show that there was an intent to give Mr. Vigliano enforceable rights. And that's just not the case. He's not a party to the contract. There's no specific language that suggests that. There's a number of provisions in the contract.
Joanna Gaines decided not to write a book, he couldn't sue her under this contract.
Absolutely not.
Not under this contract. but
Again, if
there
there's a
was
separate agreement, which is not pled here, he may have the right to do so. Presumably, if there were one, he would have sued on it. If I could address...
But he does gain a benefit from this contract, obviously, with HarperCollins publishing the 5 books. If in fact 5 books are published, he does gain a benefit.
He doesn't gain I wouldn't call it a benefit. I would say he can benefit, a payment flows from the agreement, and if it's a benefit, it's at best incidental. It's certainly not an intended.
Well, he doesn't, in other words, but it is sort of a benefit because he doesn't have to go to 1 and 2. It goes direct.
It goes directly to him. So
that's a little bit of a benefit.
So can you not argue then that he is an incidental beneficiary under the contract?
No. Well, yes, he is an incidental beneficiary. That is the best that Mr. Vigliano can do. And picking up on the agency coupled with an interest point, that is really critical here. The Peter Lampak case, which Vigliano doesn't cite in its appellate brief or in its reply, the trial court relied on it, we relied on it. It's a critical case. It is almost directly on point with respect to the language in the contract and the third-party beneficiary argument. And I encourage the court to review it. It was affirmed on
just
appeal.
tell me why here, and I think I asked this, why is this not an agency coupled with an interest?
This is, so an agency coupled with an interest, there must be a
No, I know what it is. I'm asking you why not here?
Right, because there isn't something giving him a property or a vested interest. So for example, if Mr. Vigliano had negotiated to include a portion of the copyright for the books, that would be an agency coupled with an interest. A right to exploit the works in some manner, produce a movie, but that's not in here. All we have are the plain words. As Your Honor pointed out, words are not enough. All we have is agency coupled with an interest. The case law is crystal clear. That is not enough to create an agency coupled with an interest. It's not enough to create an irrevocable right, and it doesn't give him third-party beneficiary status.
What about the tortious interference claim?
So there's no longer any tortious interference claim. During oral argument, counsel for Vigliano dropped it as to the Magnolia defendants. It remains as to UTA.
Okay.
Yeah. Last point I want to address is throughout the brief, and again today we heard that it would be an absurd result if Magnolia and HarperCollins were to sign this agreement and then terminate it the next day. While that may not be a smart business decision to sign an agreement and then terminate it the next day, they had every right in the world to do that. There is nothing absurd about doing that. They had the right to
Is there
amend.
anything that in the agreement that Vigliano could have prevented them from not writing any of the books?
Nothing. And the appeal hangs and falls on that point.
And isn't that the whole purpose of the contract?
That's correct, Your Honor.
Okay, all right.
Thank you.
Good afternoon, Your Honors. Kevin Fritz from Meister, Seelig & Fine on behalf of Defendant United Talent Agency. We were the agent that replaced the plaintiff. Obviously, for a tortious interference claim, you have to have a valid contract between the plaintiff and a third party, and as set forth in the briefing and by counsel for the co-defendants.
I mean, they have to have a breach at least. You have to have.
Well, there has to be a contract, and then to which the party can enforce, and there has to be a breach. Right. Neither of which are present here as set forth in the papers. And
there's no contract between Vigliano and the Gaines?
Not that's being sued on here. You heard the plaintiff's counsel say there may be a separate written contract, but it's not in the record, and that's not what he sued on. He sued to enforce the contract between the publisher and the author.
Yes, okay.
All right, so there's no contract. to which the
But that argument would hinge on whether or not you're a third-party beneficiary. So let's talk about whether or not the economic defense applies and whether or not there was a breach.
Right. So for the economic interest defense, Your Honor, in his brief, the plaintiff's counsel cites the Court of Appeals case of White Plains Coat and Apron, and he argues that the economic interest defense can only apply where the defendant acted to protect their own legal or financial stake. And one of the examples given by the Court of Appeals in White Plains is where the defendant had a managerial contract with the breaching party. The plaintiff's complaint alleges that in 2018, the authors fired their manager and hired my client, and then the alleged breach is 2 years later. So we did have a managerial contract that we're allowed to enforce. And so the economic interest exception does apply.
And is there anything illegal or illegal, immoral, or terrible that you did?
There's no allegations of malicious conduct,
Right.
fraudulent conduct, immoral behavior. In fact, recently in the Ocean Trails case, which I know a number of the justices on this panel were on just 2 weeks ago, the court said plaintiffs do not claim that Searchlight or Credit Suisse employed fraudulent or illegal means in connection with the subject transaction. They also failed to sufficiently allege malice. Same situation here. There's no allegations of any of that type of misconduct. Thank you.
Thank you.
So a few short points. We can't force anyone to write anything, okay? We agree. The issue is, what happened here is that Ms. Gaines did write the book that was precisely described in the publishing contract, but gave it to a different agent, and we're not getting the commissions on that. That's what the breach is. The second point I want to make is that we agree we can't amend this contract. We're a third party, we can't amend it. But once our beneficial interests are vested, and this is what Fee Corps said, the First Department case from 1979, once we have reasonable reliance and we've received some direct benefit, our interests are vested. They can't be taken away. So once we get the commissions on the first couple of books, they can't then make an amendment saying you're not getting commissions on anything else. And that's the Fee Corps case, First Department, 1979. And there's a number of trial court cases that follow it, Purchase Partners 2, Barnum, DeBoer. It's in our reply on pages 16 and 17. So they can't take it away. We can't amend it. They can amend it for whatever reason they want, as long as they don't touch the rights that were directly given to us. And to establish that we're an intended beneficiary, there are two ways, according to the Dormitory Authority case, the Court of Appeals, that we could show we're an intended beneficiary. One is that we're the only party who can enforce the rights, and I think we have that because nobody else is going to sue to get our 7.5 commissions on the fifth book. We're the only ones. Ms. Gaines isn't going to sue. The publisher's not going to sue. We're the only ones. Nobody else has standing to sue for our commissions. On that basis alone, we should be an intended beneficiary. And the second is the intent. What's the intent of the publisher and the Magnolia respondents in entering into the publishing agreement? Did they intend to give us an enforceable right? And I think if you look at 4K, the section on page 89, I think the answer is yes. There's so many things in there that show that they intended to give us rights to these commissions and that we could enforce those rights. All of the agency cases find that there is an intended beneficiary that's been cited here. There's a couple of cases that say incidental beneficiary. They're not agents. They're not brokers the way that we are here. And the final point about tortious interference that was raised about how UTA has a managerial contract. We know that they're now the managing agent. We know that, but we don't know when. You know, they say we allege it happened in 2018. We didn't plead that. We don't know when. You know, they can't just come in, come into a new agreement which breaches our agreement and then say, hey, we're a manager, so we're immune under this economic justification theory. Maybe if they were the manager before.
If there's no breach, if we find there's no breach, then you have no tortious interference claim. Right?
Correct.
Okay.
Thank you. Thank you both. Thank you all.